Recording in progress. Good afternoon, Judge Gweli.
Good afternoon, Justice Maya,
Are you well?
Deputy Chief Justice. Yes, thank you.
All right. Are you comfortable?
No, I'm trying to cope. There are a lot of goosebumps in my...
No, settle down. You are in a safe circle. Don't worry about anything.
Thank you so much.
Okay, we will start your questioning now. You hold 3 law degrees, legal degrees.
Yes.
Which are
Deputy
they and
Chief
where
Justice.
and when did you get them?
The first one, I got it from the University of the North.
Is that the BPROC?
The BPROC, yes, the old BPROC. And the second one was an LLB because in the olden days, BPROC was not mixed together with LLB. Now, the third one is LLM. Both the LLB and the LLM, I got it from UNISA. I did it through correspondence whilst I was working.
What was your area of specialty in your LLM?
I did coursework and I did the following courses. It was constitutional interpretation, advanced criminal law, advanced law of evidence, and the last one was winding up insolvency and administration of estate.
I see that you started your legal career in 1988 as a prosecutor.
That's correct, Deputy Chief Justice.
And you became a magistrate a few years later in 1991.
That's correct, Chief Justice, Deputy Chief Justice.
You can just call me Justice Judge Gweli.
Thank you.
Thank you. And during your stint as a magistrate, you also lectured at the Justice College?
Yes.
Lecturing to other magistrates?
Yes, that's correct, Justice Maya.
So you rose through the rank, became a senior magistrate, then a regional court magistrate.
That's correct, Justice Maya.
And you remained in the magistracy until 2008.
I didn't hear properly. Can you repeat, Justice Maya?
You remained in the magistracy until May 2008.
That's correct, Justice Maya.
And in the following month, June 2008, you became an acting judge.
That's correct, Deputy
Justice
Maya.
And the rest is history.
Yes.
How long have you acted at the Supreme Court of Appeal?
Supreme Court of Appeal?
Yes.
It's for a full year from the 1st of December 2020 up until November 2021, meaning full 4 terms. But I was called again this year from the first day of June up until the end of September, meaning that was an additional term. If I talk about the terms, it's 5 terms. But if it is in terms of the time, it's 1 year and some 4 months.
All right. And before you were called to act at the Supreme Court of Appeal, you had actually enjoyed some leadership stints in the High Court. You acted as a DJP.
That's correct. At Northwest High Court, where I was initially appointed, I also acted 2 terms at Mpumalanga High Court, where I later requested a transfer to.
Do you believe that those acting stints in the leadership position now prepared you for the Supreme Court of Appeal in any way?
I think so.
How so?
My reasons are, as a leader in a division, you are expected to, one, have a lot of experience, which experience enables you to be able to impart knowledge on your subordinate, mostly those that are junior. The second reason will be, as a senior or as a leader, when you do allocations of matters, you also allocate matters to yourselves, and those that are complicated or probably, if I may use the term high profile, you will always allocate them to yourself. In that way, you manage to even hone your skills further.
How many judgments have you written at the Supreme Court of Appeal?
I have written plus minus 8 judgments. The 9th one, I wrote it during this term. It has already been delivered before the end of the term.
And I see that you've written on a wide variety of topics, legal topics, that is.
Indeed, Justice Maya.
How have you found your experience in that court overall? How would you describe it?
First thing, the workload is very high. Secondly, most of the matters, in fact, I can say almost all of them, they involve intricate legal issues. Thirdly, the atmosphere in as far as the court situation is concerned, the circumstances there, I found it very warm. I was warmly received, despite the fact that most of the time, if not almost the entire time of last year, you as the President of the Supreme Court of Appeal, you were not there. But I was warmly received by the Deputy President who was there, including all the seniors whom we usually refer to them as presiders. They warmly received me. They gave me a lot of guidance. They gave me a lot of support. And I managed, through the daunting task of those intricate cases through their help. As a result, I even managed to hand down judgment timeously. So the atmosphere was excellent for me.
The last part of your response was going to be my next question, because I wanted to find out if you struggled with the workload and keeping up with the pace.
I didn't. The delivery of my judgments, I don't want to waste time to go and look at them one by one, but they were all delivered timeously. There is no one in the Supreme Court of Appeal which was delivered late. I may sound to be repetitive, but a very good example is the one that I did this term. I think I have the date. It was heard on the 17th of August, if I'm not mistaken, and it was delivered on the 22nd of September. It's almost a month and some few days.
Yes.
It's almost a month and some few days.
That's a very good turnaround, Judge Khweli. On to another take now. You are a founding member of the South African chapter of the International Association of Women Judges,
That's correct.
and at some stage you were its president.
That is correct, Justice Maya.
And then at some stage you were the president of the Africa region of the mother body itself, the International Association of Women Judges.
That is correct, Justice Maya.
Can you just tell us very briefly what these associations do, what they seek to achieve?
It is an association of women judges. Its mother body is in Washington, as you had correctly said, in USA. Ours is a chapter. That is why we call it the South African chapter of the International Association of Women Judges. Its main objective is to advance the culture of human rights. It's the other, through training, the other objective is to advance women. And when I'm saying women, although the primary objective is women in the judiciary or in the legal fraternity, but also to advance women at large.
Have you finished?
Yes.
All right, thank you. Do you believe that they are achieving their goals?
The association, if I may ask Justice Maya, are you referring to the association?
Yes. Well, let's deal with the South African chapter.
Yes. It took us a long time because we started the association in 2004. But yes, it is. I'm saying that because one, we have programs that are advancing women rights that the association is embarking on. It's a lot of them. If I can talk about them, we won't finish. Two, in as far as the advancement of the women in the judiciary, yes. We have strived to encourage, push, mentor a lot of women judges and magistrates in the legal profession to advance to higher position. This
Yes.
resonate well with the issue of transformation of the judiciary. I will start with yourself, Justice Maya. You are a founder of this association. You have been in the association for quite a long time. We have strived from long time ago that we should advance women in the judiciary so that there can be 50-50 representation of women and men in the judiciary. We are not there, but at least today you are there sitting as the Deputy Chief Justice, which is a win for us. I don't know how to explain it, but that is a win for us. There are a lot of women judges that I can quote that had advanced to the Constitutional Court who are members in this association. There are a lot of women who advanced to the Supreme Court of Appeal, a number of them who belong to this association. There are a number of women who became regional court presidents, regional magistrates, senior magistrates who belong to this association. There are other women, I don't have a list, but I can just give you an example by, I think, a judge in Free State, if I'm not mistaken. It's just an example. Chesiwe, I think it's Sharon Chesiwe. She was not our member, but we recommended her to the position of a judge. I'm just singling her out, but there is a number of them who are from the legal professional bodies who are not women. By that, I'm trying to say that we not only advance women in the judiciary only, but women at large. Lastly, if I can just mention that we have developed a training arm of the association with a gracious donation by our current Chief Justice. We established a trust. This trust is the training arm of the association. With the trust, we aim to train or further advance women, and I'm repeating, not only women in the judiciary, but women at large, by doing a lot of training where we see the gaps. So we have started, and we are currently developing materials in as far as that is concerned. If everything goes well, our training will start in 2022. Thank you.
Thank you very much, Justice Kwele. I can see that you are sufficiently relaxed now. I will hand you over to the rest of the commissioners. Colleagues, do you have questions to put to the candidate? Commissioner Dodovu, AP Betze, Moimane, Lucas, Nyambili, TBC, the Minister, OPA. That's everyone. JP Mlambo, you sure you don't have a question? Yeah, I have it. Thank you. You can go ahead. Commissioner.
Thank you very much, Deputy CJ. Good afternoon, Justice Kwele.
Good afternoon, Commissioner.
Just two questions quickly. The Prescription Act, it is Act number 68 of 1969. And I can see that you have written two judgments at the SCA regarding this provision of the legislation. Now my question is, don't you think the time is up that this act must be reviewed? Because there is always a contention about its interpretation. Don't you think that the time is right to review it? I hear bringing you to two cases that you handled, the Van Heerden case as well as the Akus case. In both instances, the contention is about the interpretation of the date of the commencement of the prescription. Don't you think that the time is up? Because one of the accusations or one of the attacks against you by the BLA is the fact that whilst you write good, solid, well-reasoned judgments, you tend to follow the law of precedence religiously without bringing in some innovation, or you lack intellectual backbone. Don't you think that the time is okay so that we will revisit that?
Thank you for that question, Commissioner Dodovu. Your question is a yes and a no. Yes, I believe that when the time is ripe, acts like the Prescription Act can be reviewed. But I'm emphasizing the fact that when the time is right. Because we do not just review the laws for the sake of reviewing them. Because you already touched on the comments that I've noted from the Black Lawyers Association, which comments are adverse to me, although they are recommending me. And although the tone of the language there, it's not so pleasant, but I respect their comment. I definitely respect their comment. But with due respect to the Black Lawyers Association, I think I dissected their comment for about 3 times. I dissected the criticism that was leveled against me there. I also dissected even the cases that I referred there. And if you can look at the very same case, if we can start with the Brumaire one. Chairperson, can you allow me a second to go there, because I want to refer to paragraph 17 thereof?
Yes. I think you're looking, well, you'll know your record better than me.
Yes. I found it. In paragraph 17, I quoted a case that was done by the then Justice Museneke, who later became a Deputy Chief Justice. And in paragraph 18, I quoted the case of Macmillan versus Bate. And I think the important part that I wanted to refer commissioners to is paragraph 19, which deals with Macmillan versus Bate. And in there, in short, I'm trying to say that the Macmillan versus Bate is on all fours with the present matter, or with the facts of the present matter that I was dealing with. But with that, I want to say this. It is important for one to know that we as judges do not just deviate from precedents just for the sake of deviating and wanting to develop the law. We do not just deviate for flimsy reasons. The important things are the facts of the case, the circumstances of the case that is before you, including the law applicable thereto, dictate or gives you a leeway of deviating or not deviating. Another important consideration which we as judges look at is, and which is important, is the manner in which the pleadings that are before you are phrased. They always guide you as to what the legal issue that is before you are. But in short, I want to say, there should be good grounds or special circumstances that must exist before one can even decide to deviate. Put it in another form. Deviation from a precedent which is a law in our country, must be warranted. It must also be rational. It must also be reasonable. So, in the matter that I have been criticized of, we took all that into consideration, that we don't just deviate for the sake of deviating. Or going back to what you asked me, Commissioner Dodovi, you don't just review for the sake of reviewing. But in addition to the facts of the matter that I was dealing with, Brumet versus Brumet, the facts of the matter were such that there was no cry for looking at the section 39(2) of this Constitution that they quoted there. This is why even the senior counsels that appeared in that matter did not even urge us to go that route. Finally, the judgments of the Supreme Court of Appeal unlike in the high courts. In the high courts, there is many at times where you are sitting as a single judge, you write a judgment on your own. But in the Supreme Court of Appeal, we sit normally being 5 judges or justices, in most of the time, a panel of 5 members. So if it is a judgment like the judgment that I penned, yes, we may call it my judgment, but it is a judgment that had a collective ideas of 5 members. You can even see there that they all concurred. Now, if you can even look at the judgment, the panel thereof consisted of 3 most senior and
No,
seasoned
it's okay, it's okay.
judges.
Chair, I'm satisfied with the response that I received, and I forgo my second question.
Thank you, Commissioner.
Because it had to do with the precedent system.
Yes.
Thank you. It's okay.
Thank you.
I'm
If you
satisfied
can
with
allow
the
me,
response.
Justice, Deputy President Petse was the presider in that matter. Justice Mba was also a senior member in that matter. A seasoned judge, Justice Zondi, was there. So, in short, there was no need at that particular time. The matter didn't call for that, and hence my answer initially was a yes and a no. So if the circumstances requires that or calls for that, yes, we will depart from precedent. Thank you.
May I just make an entry, Justice Khwele, that you try and keep your answers as brief as you possibly can. I don't mean to interrupt your flow of thinking, but just try a little bit.
Thank you.
That way you won't sit there for a long time.
Thank you, I noted that, but I'm sorry to say this, that was the only adverse criticism against me,
Yes.
amongst all the comments that I received, so I had to deal with it thoroughly.
All other comments having been positive.
All of them.
Thank you, Judge Khwele. AP Beth, it's your turn.
Thank you, Deputy Chief Justice. Good afternoon, Judge Khwele.
Good afternoon, Acting President of the Supreme Court of Appeal.
In the interest of time, I would not go into pleasantries. You are aware that when it comes to the interpretation of any legislation, a judicial officer must always keep the provisions of Section 39(2) of the Constitution at the forefront of their minds.
Indeed, AP,
You appeared before this commission on 21 April 2019 for the position of the Deputy Judge President for the Mpumalanga Division. And having had the benefit of reading the transcript, then you said that you did not even contemplate availing yourself for appointment to the Supreme Court of Appeal. What I want to find out from you, what factors weighed with you that made you believe that it is now time for you to raise your hand?
Thank you, Acting President. At that particular time, even the transcript will reveal I was just new at the SCA. I even indicated the fact that it was too early for me to say I am going for a position at the SCA, and that is why I availed myself to the position of a Deputy Chief Justice. But I think that I have gained enough experience from the time that I spent at the Supreme Court of Appeal, including the time that I spent at the Supreme Court of Appeal this year. In addition to that, I bring more than 3 decades of a wealth of experience as a judicial officer, sitting on the bench, presiding over civil, criminal matters, constitutional matters, family matters, a lot of them. And I am of the view that during my acting stint at the Supreme Court of Appeal, I demonstrated my capabilities and my competency in as far as adjudication or adjudicating matters on a high level at the Supreme Court of Appeal.
You have been a judge for about 13 years now.
Indeed, AP.
And with that length of service, I was hoping that in your documentation, I would find a list of judgments reported that you wrote as a judge in the High Court. Can you tell the Commission, perhaps from the top of your head, of how many reported judgments did you write in the High Court?
Can you just give me a sec so that I can just write and add a little bit? The ones that I could immediately find, I think, if I'm not mistaken, they are about 5 or 6, except those that I wrote, but I was with other members of the panel, not alone.
Have you got that list in your documentation?
I don't have a list, but I can, even in the list of the judgment that I've noted in my questionnaire, if we can go to my questionnaire. I know out of my head the Sheldon versus Lakey matter, whilst I'm still going there, is reported. It is in my questionnaire. And I also know about the Matitwani versus Regional Court President and another, 2018, in brackets 1, SACR 3209.
In any event, your answer was that over 13 years you wrote 5 judgments which were reported.
That is why I said subject to my counting being correct, and I said plus minus. But I didn't make a list, but I only coded 2 in my questionnaire because the questionnaire was saying at paragraph 16.2, it was saying, perhaps I should start it at paragraph 16.9. It says, list the cases where you have a written judgment which you regard, not more than 10, which you regard as being the most significant. And I mentioned the list, and that list also includes those that were not reported. So the second paragraph says, the second question says, which of these cases, meaning the ones that you regard them as most important, has been reported? And then I quoted Sheldon Lakey, but it is only one there. I also included Brightwater, but Brightwater is from the Supreme Court of Appeal, because those are the ones that I said they are the most significant. So I didn't list all the others, like the Matitu one, it's only that I can remember it for now. I didn't include it at that particular time because these 2, I thought that they are the most significant to me.
Thank you. I see from the judgments which form part of your documentation that the majority of them are the judgments that you wrote at the SCA.
In that I attached. Indeed.
Yes.
Indeed, AP.
And you did mention earlier on that with the judgments that you wrote at the SCA, you received assistance from the other members with whom you sat.
Indeed, Acting President.
The feedback that I received from the presiders, all of them without exception in those cases, is that the final product is materially different from what you had produced as your first draft. And that much had to be done to your judgments to get them to a point where they could be delivered as judgments of the court.
Can I respond? I'm not sure whether
Please.
you are finished. It can be partially so, but the help and support that they gave me was in as far as, one, advising me in terms of the style of the judge, what the writing style of the Supreme Court. The writing style of the Supreme Court, I think most of us know, is not the same as ours in the High Court. The High Court, sometimes we tend to elaborate a lot. Sometimes we tend even to include cases that are tried, is tried law. But we are learning, we are trying to improve on that, on the judgment writing style. But at the Supreme Court of Appeal, all the judgments that are, I mean, the cases that you refer to that are tried, that is tried law, I was advised you don't even need to mention them. So you will find that in my initial judgment, I elaborated on a particular case or authority which was tried. So in that manner, you'll find that the other cases that were tried, that I tried to probably to elaborate more, were taken out by the advice of the presider. We even know that even in the Constitutional Court, they don't write, their writing style is not exactly the same as the SCA. So, but the fact of the matter, DP, is the following. As far as the structure of the judgment is concerned, my judgment was always okay. As far as capturing the facts of the matter is concerned, I believe my judgments were okay. Even most importantly, the application of the law to the facts. The presider agreed with me and the approach to the judgment. Thank you.
In the normal course, you would receive suggestions from the other members of the bench, which would be incorporated into your judgment in track changes, in effect changing the judgment that you had produced. It was not a question of crossing T's or dotting I's and so forth. The suggestions were matters of substance, not stylistic.
It's a pity, AP, I was not aware of these adverse remarks from the presiders. It's a pity I was not made aware about it beforehand. I will have probably tried to prepare and bring those track changes, because I believe some are still in my computer, so that it can be, or the panel can be able to see whether they were matters of substance or corrections there and there. But in my own belief, I respect their views and what they informed you. They were not matter of substance. Thank you.
Don't you think perhaps it would help you if you were afforded more acting stints at the SCA to enable you to gain more experience, and hone your judgment writing skills?
No DP, no AP, sorry.
I'm sorry, I didn't get the answer.
My answer is no.
Thank you. That's where I will leave it, Deputy Chief Justice. Thank you.
Thank you.
Thank you, Deputy Chief Justice. Good morning, Justice Kwele.
Good morning, Commissioner.
Just one question from my side, which was prompted by your response to the Deputy Chief Justice in your leadership role of the South African chapter of International Association of Women Judges. Do you think that patriarchy is an issue in the judiciary? And depending on your response, what is your view on the issue of gender parity being one of the criteria to be considered by this body in its process of filling vacancies to our judiciary? Thank you, Justice Kwele. Thank you, Deputy Chief Justice.
Through you, Deputy Chief Justice, can I ask Commissioner to repeat the second one? I didn't get it in full.
Yes.
Do you think that the issue of gender parity,
Yes.
as a criteria, must be added to a number of criteria that we must consider when we deliberate on the filling of vacancies as an aspect of cushioning the effect of patriarchy in the judiciary? Thank you.
Thank you. The answer to the first question is that, yes, patriarchy, in my own view, I think it's still an issue that inhibits the fast transformation of the judiciary, because if you look at the judiciary, the leadership is still composed of a lot of men. But it is not only that. Remember, when we talk about transformation, we talk about the issue of even transforming not only the numbers, or we transform the mindset of our male counterparts, mindset of the leadership in the judiciary. So I think sometimes that is where maybe the problem is. There's still a lot that needs to be done in as far as transformation of the mindset is concerned. The JSC has said for quite a number of times in this. There is a very, very slow pace if you can look at the transformation, especially of the Concord bench. We rarely see the appointments of women there. 2, in the SCA, it was better. We have improved a lot. But I think if we can deal with the issue of the mindset in as far as this issue of patriarchy is concerned, we will be able to win. Your second question about the criteria of gender parity. Yes, I fully support the fact that It should be one of the criteria. But it should not just be a criteria that women should be appointed. I don't know how it can be crafted, because we really do not want parity in the sense of numbers being 50 to 50, men 50 to 50, when the women that are appointed there don't make a difference. One, they must be competent. We don't just want to be appointed as women because we are women. No, we don't want that. We don't want to raise a female card and say, because I'm a woman, I must be appointed. No, we don't want that. And we want women that sit on the bench that can be able to change the lives of our citizens out there. Because we judges, we speak through judgments, through our judgments. We must do that. We don't just have to be on the bench there just to make numbers to be 50-50. No, but I fully support that it should be there. It should be taken into consideration how the JSC crafts it. I cannot spell it out. I'm sorry. Thank you.
Thank you, Justice Kweli. Thank you, Deputy Chief Justice.
Yeah, it was your turn anyway.
Thank you very much. And TCJ, you will understand why my voice is good. Thank you very much. I just want to once again congratulate you and also agree with Just Kweli that it is a victory for us as women to have you in the seat where you are. And I'm saying that because my question, good morning, Judge Kweli.
Good afternoon, Commissioner.
Is it afternoon
Lucas?
already? It's fine. I slept late last night, so to me, I'm still at night. I'm still in the morning. Yes, we met in Kimberley the first time when you came there with the international chapter and so on.
During the conference.
See, during the conference. So when I saw you this morning, I was just like, where did I see this person now the last time? And I remember that we appointed you for DJP of Mpumalanga. But in fact, my question was about the issue of, I was looking through the issue of demographics, and I want to agree with you that you have, at least there was a lot of progress under Justice Maya at the Supreme Court of Appeal in terms of appointing capable women in their positions. But there was something that I wanted you to address, is that in your own view, how do we really, what do you propose we do to address the concern that we have, the very same issues that you raised of capacity and capability of the women that we appoint? Because we are seeing many women that is being appointed, but there is still that prejudice that we just appointing women, they are not the best that we are appointing. I just want to listen to your own view in terms of that, and what do you propose we do to address that attitude so that we can see more women being empowered, let me put it like that. And then I want to summarize as the next one is, and then according to yourself, what would you say in your career is as a jurist, was the moment that you feel you are really now accomplished? It is like what people will say, that wow moment as a jurist. That will be my questions. Thank you.
If I understand your question well, Commissioner, but you'll pardon if I didn't comprehend it properly, but I think you are talking about women or judicial officers that are already appointed on the bench.
I would want you to be a little bit general, but
Okay.
not too general, so that it won't be, take a long time to
Training is very important. Our women who are already appointed and who are also not important, it's very, very important. And probably I'll go back to the association. That is why we thought that we must have a serious training arm in the association. We did that with the full acknowledgement of the fact that there are a lot of training that is occurring in the judiciary. We have the what we call SAJ, South African Judicial Institute Institute of Education, which is training the judiciary at large. And I come from a viewpoint that training can never be saturated. And you cannot, if you are a person, you cannot stop being trained. I know my sister association like Saola, their members are here. They also do training. But in short, there's a lot of training that is occurring, but to address the issue in the judiciary, that is why we said we must really embark on doing our own training where we upskill women. And it's a pity I don't have the objectives of our training in as far as the association is concerned. But we envisage even training all the women. One, whether you aspire to become or to go to a higher level or not, we have developed that kind of training. Whether you don't want to go to a higher level, we have embarked on that training. For example, the social context training, which we find it as key, very key to judicial officers. We still need to do social context training. Unfortunately, one of the product of the first social context training that that was embarked on when I was still at Justice College, when I was training magistrate, with the funding from the Canadian. We called it an intensive social context training. I was one of them. And through that, we managed to train a lot of magistrates at that particular time so that we can infuse the human rights culture, the civil rights culture into the law, into the judgments that we deal with. So it is very important. But I was trying to say, even if you don't want to aspire to a higher position, that kind of training is needed so that we can have good jurists. We have a specific program that address those that wants to aspire to the leadership positions. We call it a leadership and management course. There is a lot that we are dealing in as far as training is concerned. So I will say training is important, Commissioner Lucas. That's how we can empower women. Now, the second question relates to what I accomplished as a wow. It's a difficult question for me, but I'm going to try. There's a lot, in fact. That's why I'm saying it's a difficult comp. My accomplishment as a judicial officer, the first one is having served as a springboard, having encouraged, having supported a lot of women, even if I was a junior to them, to advance to higher positions. That was a wow for me. 2, I did training. So training is a passion for me because I imparted a knowledge to so many in the department, even including interpreters and the clerks of court, everybody there. The third one, the last one, is transforming. I usually talk about this because it's my passion. Transformation of the judiciary, which I did when I was sent to Appington. I did a lot there in transforming the office. That was a wow to me. When I left that office, I was more than satisfied. Thank you.
Are you done, Commissioner Lucas?
No, actually, I was shocked that you mentioned Uppington. It might sound as if I am biased because I'm from Uppington.
You may ask your follow-up question.
I just wanted one thing. You speak that there is a lot of training and so on, and you are empowering women. How are you also addressing the issue of men? Are the men that is involved in the training sessions when it is like for just actually to change the mindset? How are you also contributing to that part? And then, thank you, Mrs.
Thank you, Commissioner. Indeed, we are. For example, when I was at Justice College, we were training, it was not specifically meant for women. But probably I concentrated on training on women because of the fact that we still need a lot of women in as far as gender parity is concerned. But the long and short answer to what you are asking me is that even the training material that we are dealing with, we will even try and include the members of our association in the training. In our association is not only composed or comprised of women. We have men who are members of our association. So the training is specifically aimed for members of our association, which are both men and women. But the social context training, which is important, is across the board. Thank you.
Thank you very much, TCJ. Thank
Commissioner
you.
Nyambi?
Thank you, TCJ. Afternoon, Judge Khwele.
Good afternoon, Commissioner.
We have served as a judicial officer for more than 31 years.
Indeed.
18 and 7 months as a magistrate and 13 years as a judge. And the Supreme Court of Appeal is a very important division in our country. As somebody that has acted for more than a year at the SCA, if you can single out 2 critical challenges that you think you are going to assist to address, if you can be given an opportunity to be a permanent judge at the SCA.
Firstly, as you indicated, I've got 31 years experience sitting on the bench. I have vast experience in civil, criminal matters, administrative, constitutional matters, social context, which in my view will be able to bring a change in as far as the decision making is concerned in the Supreme Court of Appeal, which resonate with the thinking and reasoning post 1994. Two, that if you have already said I have a lot of experience as a magistrate. As a magistrate, you also deal with a lot of issues around family law, issues especially about criminal law, those issues, in my own view, deals with issues that affect people on the lower ground. If you can even look at some of my judgment, you will realize that in all my judgment, even including the Supreme Court one, not sure if you can just give me 1 second, I can quote one. I don't think I included it in the...
Judge Gwele, maybe to assist, it's not only about your experience. I'm interested in challenges facing SCA.
Okay, thank you. Thank you for the correction. Let me revise. One that I can immediately think of is gender parity, because then if more women are appointed in the SCA, it will bring hope to our citizens. Yeah, I can think about that in as far as challenges are concerned.
My last one. Any other thing that you might consider your weakness that needs some attention? What is your weakness?
I cannot think of any weakness that can need an attention for now. I know a weakness can be a weak point, but in most of the time, I think my weaknesses gives me a strong point, because I am a very calm. I can adapt to any situation. at any time, so I don't think there's anyone that I can think of now that need attention.
Thank you, Judge Well. Thank you, DCJ.
Commissioner Marumachai?
Thank you very much, Acting Deputy Chief Justice. Good afternoon, Judge Kwele.
Good afternoon, Commissioner.
I want to ask two questions, but before I do, just one for clarity. Did I understand you correctly that in light with the criticism that BLA leveled against you, you believe that it's unfair because in the matters that they referred to, Section 39(2) was not applicable? Did I understand you correctly?
No, I don't think you understood me correctly. I am not saying their criticism is unfair, not at all. Because that is how they interpreted or understood the judgment that I wrote.
Okay, let me try to assist you perhaps. The question I'm asking, that let's leave the BLA aside.
Okay.
In the two judgments, Truta and Bruma, Bruma dealt with the anti-nuptial contract, and we know how those contracts generally affect women in society. That was Bruma. Truta dealt with personal injury sustained by a medical procedure, and we understand the constitutional issues that might arise out of that from a health perspective. So I just want to understand, are you saying that in those two cases, Section 39(2) did not find application? That's what I'm trying to understand. Let's forget about the BLA.
In true time, maybe, but I'm saying in Brume because they were criticizing my judgment. In Brume, I'm trying to say the facts of the matter that was presented before me didn't cry for that.
I'm not sure if you were able to pick up, but Acting President tried to assist in that regard, saying Section 39(2) actually finds application all the time. I'm not sure you were able to pick that up,
yes,
because of what it deals with. And the thing is, this then lead me to the point that I want to pick up with you. And you said it in one of the comments that you made, that in your judicial career, you want to change lives of our people out there. And I think when one looks at the BLA's comment, it's not a criticism per se. It's actually a call for consciousness to say, let's look at the Prescription Act. If it was as clear as we think it is, that after 3 years, you don't have a right to come to court and all those things your claim has prescribed, we wouldn't have as much litigation as we are having. And what they are saying is, continuously, various courts, including the Supreme Court of Appeal, I'll go further and say even the Constitutional Court, they bring judgments that really causes confusion in the application of this particular legislation. And they raise a particular provision on it, Section 12, subsection 3. And they are saying that particular provision, it requires some judicial innovation to assist us while we are waiting for Parliament to get its house in order. So what they are saying is, you seem not to be doing that, but religiously follow. Perhaps maybe the intellectual backbone comment might have been too strong. I don't subscribe to that. But what I'm saying is, that particular legislation, when you look at it, and the different judgments that have came forth, the comment is you religiously follow precedent, even in instances where you can deviate, given the court where you are, the Supreme Court of Appeal. That is the comment. I'm not sure it's a criticism. It is just an awareness to say, as not only you, but all the judges, like, let's look at this thing. I'm not sure, do you have a comment on that?
I have, but the way it was phrased, it was specifically referred to me. the way it was written there.
Indeed.
Yes.
But I'm saying functionally.
But that is why I'm saying, I'm not even saying it is unfair. It is a fair comment. And you will remember that I answered that question in relation to the question that was asked by, I think it's Commissioner Dodovu. And his initial question was, is there no need for a review of the Prescription Act? And my answer to that was yes and no. And that is why I said my answer was, and I fully agree with you, that we should be aware of this. We should include the Section 39(2) of the Bill of Rights. We must always think about it when we interpret legislation. I'm fully aware of that. But to say yes in particular or in reference to this matter, I'm saying the facts of the matter at that particular time didn't dictate that. But I fully agree that yes, it needs to, it can be. And that's why I gave an answer of yes and no.
Can I ask a last one?
Yes, and let's just have a crisp question,
Yes.
please.
In relation to, I mean, currently what we are seeing in our courts, we look at the people who are litigating in the courts, mostly are white male, right? And we don't see women in particular leading cases in most of the cases, especially in the Constitutional Court, from all the races. What has your role been, not from a judicial point of view, but from a practice point of view? Because we draw judges from practitioners, right? And it is that practice that will enable them to become better judges, at least that's a belief. What has been your role in ensuring that young female practitioners are able to more and more appear in perhaps maybe the Northwest, the local, the division in the Northwest and the division in Mpumalanga? Thank you very much.
Are able, if I want to get more clarification, are you saying are able to appear
Yes,
in the courts?
to run matters in the courts. I know that you are not the one who's briefing them, but I'm just saying from a transformative point of view.
Yeah. As far as practitioners are concerned, the role that I can only talk about is that when I was still at Mpumalanga, when I was an acting deputy judge president, we held a sort of like a seminar, but there's a terminology that we use, wherein we were not necessarily training, but talking about the law, empowering them in as far as the law is concerned, at Middleburg. At Middleburg. Here's the term, sort of trial advocacy. Yes, we did that when I was in Middleburg. But maybe let me just add a little bit, because in as far as women who are not even yet attorneys and advocates, I think almost the whole country, we are having a mentoring program that flourished during my presidency, where we mentor law students in all the universities. Thank you.
Thank you.
Commissioner Noches?
Thank you, Mr. Chair. Good afternoon, Justice.
Good afternoon, Commissioner Noches.
Yeah, look, would you agree with me that for judicial appointment, there is different standard for the High Court and the Supreme and the higher courts, like the Supreme Court of Appeal and the Constitutional Court, in that for your High Court at least, potentially you must demonstrate. But for the SCA, you must definitely demonstrate that you are an all-rounder, you are ready, you are a jurist, you are a judge. Do you agree with me on that proposition?
I fully agree.
In order for this body to conclude that, for instance, in your case, that you are indeed an all-rounded judicial officer who is ready for appointment in the SCA, that must be determined with reference to your judgments.
Yes.
In this case, you have only attached for us the judgments of the SCA and one judgment of the full bench from your division. And we just don't have judgments where you sit by yourself, except for those two judgments that you have referred to. Or perhaps you suggest that there are 5 reported judgments that you have. My question based on this, taking into account your debate with the acting president of the SCA and what we have, would you say we would be in a position to determine whether, as a person, you are ready for the SCA in the sense of you being a complete judge who has established a jurisprudence of her own?
Thank you. I just want to go to the summary of the judgments that I attached. The first one that I attach, I'm going to start there. The Leone versus Leakey versus the state. Leone Leakey versus the state. It deals with it's criminal matter. It deals with rape. So in that sphere, I'm fine. I just attach it, for example. The Sajwa royal family deals with administrative law. Now, the bride water props also deals with administrative law, including the principles of legality, including the issue regarding Section 1721, which deals with the just and equitable remedy. It touches on the Constitution. I'm going to skip Pretoria, DPP Pretoria versus Zulu, because it's a criminal matter. I have already dealt with that one. Now, the Brume one that we have been talking about, it's civil law, which deals with prescription. I have others, I think 1 or 2 others. The Cipla versus Miriam.
Sorry, CJ, if acting CJ, if I can stop here. I've talked to judgment where you are writing by yourself. You are by yourself. These are the judgment, I agree. These are your full bench and the judgment of the SCA where you are a collective. I'm saying your own judgment. Can you refer me to that?
I didn't attach them, but I think our report judgments and most of my judgments are reported in SAFLI. I didn't attach them. They are reported in SAFLI. During my last interview, when I checked, I have especially in the High Court, more than 200 judgments that I penned. And they vary from various sections of the law. So I didn't attach them. I attached a few because I cannot attach all of them here. And to be honest, they are not all in my head. Yes, for now. So that is why I was trying to demonstrate about the ones that are before me. And if you do not want me to go to the Supreme Court of Appeal judgments that I dealt with to show that I dealt with various aspects of the law there, which which I gained experience on, then I will end here.
With your leave, CJ, this is my last question. The difficulty I have with the judgments that you referred to of the SCA, we have already heard the remarks by the presiding officers in those cases. That's my difficult first, that the presiding officers had some remarks, you needed to hone your skin in that regard. Now we wanted your own judgments where you have written, and then you don't have. We have to go to SAFLI. My last question, which is just what I want to establish from you, is bearing in mind that the Supreme Court of Appeal, save with the extension of the jurisdiction of the Constitutional Court in respect of constitutional issues and public interest, but the SCA on its own is a highest court in terms of those matters that it is, matters that concerns to law and all that. And the judges that are in that court, in my view, must be ready, not just a potential, because they must give directions to courts in the to judges in the High Court, and must develop the law in the Republic. All what I would like to hear from you, what is your judicial philosophy, and where that becomes apparent in terms of your judgments? That's my last question.
My judicial philosophy is based on the fact that we are having a constitution, which is the supreme law of our country. But I come from a viewpoint that the constitution, it's not like a closed a book, or where if you interpret it, you must just interpret it literally. I come from a viewpoint that in as much as it is the supreme law of our country, when we interpret it, we must be open. Our constitution must be a living chapter, wherein our interpretation of the existing law must have the characteristics that are enshrined in the Bill of Rights. That's my philosophy. I can quote an example of a matter in the High Court, Akas versus Akas. In the Akas matter, if you look at that judgment, there is a consenting judgment to the main one, wherein we felt so much that I concurred it with Justice Mutsumi, the concurring judgment, but we felt so much in that judgment that it doesn't bring the very same element that I'm talking about of bringing up the issue around civil rights, human rights, because that judgment was, again, unfortunately, dealing with prescription, but that it was prescription of the Maintenance Act. So we felt very much that we should bring about the fact that in interpreting the Maintenance Act and the Prescription Act, we cannot close our eyes to the realities that the women in this country suffer. We are not saying men are not affected by the Maintenance Act, they are. But women are more affected by the Maintenance Act, far more than me. So if you can look at that judgment, we are trying to bring across the fact that we should interpret it so that it can be able to protect or bring across this perpetuated treatment of women in as far as maintenance is concerned, which affects them mostly. And that is why we wanted to bring that up.
I think you have answered my question.
Okay.
Thank you very much. Thank you.
I thought you'd asked your last question. Oh, I thought you were asking another one. So sorry, Commissioner Dekis. Thank you. Commissioner Shabangumdao.
Thank you, TCJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Are you good?
I'm trying to be. With the harsh questions, I'm trying to be.
Yeah, I think I had two questions for you, and they have been covered by the other commissioners. But I just want to thank you for your contribution in the transformation of the judiciary, and also your actively involvement in mentoring those who are coming after you. Commissioner Marumo Akhai, ask you a question as to what extent are you contributing in assisting those women lawyers to be able to appear in courts? And you understated whatever that you are doing for women lawyers. Saula in Mpumalanga, in their supporting letter, they mentioned that you go out of your way to mentor young women legal practitioners. Can you maybe want to share with the commissioners as to what is it that you are doing thus far? Because I think it will cover also the question that was asked by my brother next to me. Yeah. Thank you.
Sometimes I do personal-to-personal mentoring of the legal practitioners. Especially, I will quote in Mpumalanga. I mentor them and advise them. One of the good days they requested me to give them an advice as to when they appear before me, what do I see them lacking on when they appear before me? I should sort of spell out and advise them how to present their case better. I did that to a few, and also, I think you know, Commissioner, you are the chairperson of Saola. I normally come to your conferences, and we normally address issues that relates to legal practitioner or women in the legal fraternity. And some, when they are even given an acting appointment, I mentor them on a person-to-person basis in as far as writing judgment, approaching the judgments are concerned. I'm not sure you will feel comfortable if I can mention you as one of them, but you are one of them. I mentored you when you were acting in the Mpumalanga High Court. I also mentored you when you became a president. You said to me, please assist me, mentor me in as far as leading this association is concerned. And I did it up until now. Thank you.
Thank you, Judge Hwele. I hope you will continue mentoring others who are coming after us. Thank you.
Commissioner Matolo-Lepo.
Thank you, ACJ. Good afternoon, Judge Hwele.
Good afternoon, Commissioner.
Mine is a very simple one. You know, when you appeared before us the last time,
Yes.
there was an issue about the judgment that you hadn't finished. Have you done so?
Yes.
Have you done so?
Pardon?
Have you concluded that judgment?
The criminal
Yes,
matter,
yes.
the part head.
Yeah.
Indeed.
Okay, thank you.
If you, okay,
Because I wanted
No.
you to close that part.
that chapter. I
Yeah.
did, and I did it during, not even during term. I used my time around January to finish it. And remember, it was having 32 counts. Yes, thank you so much.
Okay, follow-up question. You know, you have been talking about training, but I don't want us to come out here with a perception that only women need to be trained. You know, men also need to be trained. But in your point of view, I know that you do a lot of mentoring young female attorneys. I've seen you a lot. But there must be something lacking that we need to add. What do you think can be added to make sure that they are more comfortable in the judgment writing? And especially your organization as the South African chapter of women judges, can they assist in that regard?
In judgment writing?
Yeah.
Thank you, Commissioner. In the training that I'm saying we are developing, we do have judgment writing. In the training that we are developing, we have already developed a training template in as far as that is concerned. We have already been populated that template. As I've indicated, we are only just waiting for approval. Not approval, the training itself, which is going to start in 2022. we are definitely, it is one of the topics or the programs that we envisage in the curriculum development that we developed in as far as our training is concerned. We are going to do that. That's judgment writing. Yes.
Thank you, Judge. I just hope that you'll include men in that judgment writing.
No, we are going to do that. Thank you. And I said that it's a pity I don't have the purpose of, or the objective and purpose of our training curriculum before me here. I will read it. It says, all members of our judiciary, which are men and women. Yes, we'll do that.
Thank you, CJ.
Minister?
Yeah, thank you very much, DCJ, and good afternoon. Mine is straightforward and one question. Do you believe, in the context of one of your judgments, the Sheldon Lackey, if you don't remember the one that involved a female educator, do you believe in that a sentence does play a role in deterring other will-be offenders?
Can I ask, are you done, Minister?
Yeah, on the first part.
I heard you, let me get a correction. I heard you saying, do you believe a sentence? I'm not sure, because we have different sentencing option. Which sentence? Is it a sentence on its own, if I want clarification? Or you wanted to say custodial sentence? Or?
Yeah, custodial sentence, or any sentence, whatever sentence, do you believe that it does play a role to deter those who may be or will be offenders in the future?
Sometimes it does. But if I talk about sentence as in general, not a sentence as custodial or a correctional supervision sentence or a suspended sentence. But if I talk about a sentence in general, sometimes it does, it deter, but sometimes it does not. I believe that sometimes the issue of restorative justice helps in as far as offenders are concerned. I also believe that at the moment it's only occurring in as far as cases that involves young children are concerned. The issue of diversion. If we divert matters long before it comes before the court and long before it even deals with sentence, or we send people, or we sentence people, it can help a lot. Thank you, Minister. They said I shouldn't talk too much. I'm going to stop there.
No, you're brave this time around. Yeah, it's almost the same question, but lastly is, what do you think should be done by either the OCJ or the Justice Department or the entire cluster to educate society about the sentences or whatever, in whatever form that come out of our court? I'm asking this in the context of our country, the high prevalence of crime. And on a day-to-day basis, someone is being sentenced in this country, whether it's custodial, whether it's an Irish sentence in Musina, in the Eastern Cape, anywhere. But we still see the crime rate going up daily, despite us expecting and hoping that what goes through the system will be a deterrent. And I know that there are other factors, but what do you think could be done to educate society more about what is happening in our courts in regards to these processes and sentences, except just us relying on the media, if we are lucky to report?
I think the usual awareness campaigns that we can embark on, a serious awareness campaign that we can embark on in educating our communities. It will help. One of the other method that probably we can increase on, Minister, the Gender Directorate, they are spearheading the family dialogues. We used to partner with them in as far as issues of family dialogues are concerned, and that is where we are able to bring the whole community at issues like this. I'm talking about a family dialogue, but it cannot only be a family dialogue. We can name a sentencing dialogue or whatever that we can deal with. But I'm trying to give that as an example. In my own view, we'll be able to reach a lot of the communities out there.
Yeah, thank you.
Commissioner Mokonis.
Thank you very much, Deputy Chief Justice. Good afternoon, Judge Kwele.
Good afternoon, Commissioner. I can't see your name, but I will call you Commissioner.
Okay. No, I have two quick questions. One, what would you say to people who believe that the law is the weapon of those who own the economy to consolidate their power in society? Do you have some sympathy with that view?
Can you repeat, Commissioner?
Okay, what would you say to people who believe that law is the weapon of those who own the economy to consolidate their power in society? Do you have some sympathy with that view?
Law is a weapon of? I can't hear properly.
Okay, law is the weapon of those who own the economy to consolidate their power in society. Do you have some sympathy with that view?
In a way, because in as much as the law is supposed to be used to address and protect the most vulnerable in the society, especially in South Africa. But you will find like one, access to representation in as far as litigation in court. Most of the time it is expensive. So our vulnerable people down there, in as much as we have good laws, in as much as we have good policies that are supposed to protect them, they are not even able to get advantage of that. Now, the law must cut across. whether you are rich or poor. It must protect everybody, and our constitution is like that. But why, if you look at the law, especially some of those that are still not reviewed, and that is why we as judges sometimes are called for to be activists, judicial activists, to even try and interpret the old laws. Remember, our laws are still based on Roman Dutch law. Some are not even relevant to the current situation. I will just quote the law of contract. It dates back from the long old days. But you will find that there are established principles, and if you can look at them, they mostly protect. Did you say white? Not white, but the rich community, if I want to quote you properly. But yes, I'm saying it does not necessarily protect them, but the cases that appear before us in as far as the law of contract is concerned, if you can look at it, they mostly affect those that are rich. Whereas if you look at criminal law, it affects our vulnerable people. And that is where the issue of legal representativity comes in. But unfortunately, they won't be able, they in most of the time don't afford to pay a lot of money in as far as getting the best legal practitioners. Thank you.
Thank you very much. The last question. Do you think that there is a room for our legal system to be developed to be more inquisitorial than adversarial? If yes, how? If no, why?
Yes, it needs to be more developed to the inquisitorial one, because our law is adversarial. Although it will need a lot of efforts to change that, but I think in the meantime, it needs us, judicial officers, judges and magistrates, to not just be like a referee or umpires in court. We must be active. We must, in a way, be involved. Because with inquisitorial, the judges there are involved in the matter. I'm not saying involved in a sense of becoming investigating officers. I'm not trying to be there. But we don't want to be seen to be just umpires in the court who says, yes, you are right, you are wrong. You must be involved in the manner, but remember, there is a thin line. Your involvement should not be seen to be descending into the arena. I think we need to do more in the meantime before we can even do a reform of our judicial system. Thank you.
Thank you, TCJ. Thank you, Judge Kwale.
Thank you, Commissioner. Commissioner, madam, it's your turn.
Thank you very much, DCJ. Judge, I see you trained magistrates in Namibia.
Indeed, I think it's justice. No, Commissioner Malem, I said, even if I don't see your name, I know.
Yes, so given these borders and the unity of the African continent, do you think is there any role the legal fraternity can play in uniting this continent, since you are able to go and train the magistrate in another country called Namibia? Indeed, I believe so. Yes, and then the other issue is the issue of being a member of the Academic Advisory Board at Free State, the LLB one.
Yes.
Do you think there is a need for decolonizing education so that that which you teach our children reflect who we are and make them to identify with the continent? As a member of the Academic Advisory Board, are you playing any role to ensure that the education, especially law, that we get to teach at school is decolonized and is reflective of who we are? Thank you, DCJ.
I fully agree with you on that one. The only thing is that I think if you can see in my CV, I've not been long or roped in that advisory council. But yes, remember the laws and the laws that we teach must respond to the realities that we face as a society. Now, roping people like ourselves, like judges, firstly. As a judge, I'm not totally divorced to the realities that are appearing in life. West, I come from a very, very rural place called Khomu, if you know where Khomu is. 2, as I sat on the bench for quite a lot of time, we tried to bring, even during our training when we were dealing with training in Justice College, we tried to bring experiences that we experience when we are sitting in this court, in the lower court, to the fore and to our judgment. But now we are saying, I think roping people like ourselves is trying to bring the practical aspects of what we are dealing with in courts into their curriculum, into what they are being taught about. Because if you can look at what is happening mostly in the university, we are mostly taught theoretical things, the law, but in a theoretical sense. Once you get your LLB degree, or once you even get your whatever degree you have and you go and face now the real world of working, from that position to work, whether as a practitioner, legal practitioner, or as a magistrate or as a prosecutor, but I talk from my experience because I started as a prosecutor. It's difficult, it's not easy. To take that theory into practice, it's not easy. So we try to bring that element of advising the curriculum about perhaps things that they can include so that the student might even experience the practical aspect of the realities that is occurring in our societies, so that our curriculum are in line with it. Thank you.
Are there any questions from our colleagues on the virtual platform? Commissioner Banada is still there? Commissioner Bredenbach? Ah, there you are.
Thank you.
Do you have any questions?
I have a question.
You're on mute. Please unmute yourself.
I'm speaking. Can you hear me, Chief Justice? Deputy Chief Justice? Can you hear me?
Yes, we can.
Thank you very much. Good afternoon, Judge Gwele. Last year, the SCA in a unanimous decision overturned one of your judgments. It was about spoliation. It's one that you list. It's the matter Bischoff versus Valbeplan Boerdery. So it's about the law of property and the basic aspect of spoliation. And the two requirements: one, there must be peaceful, undisturbed spoliation, possession at least, sorry, and secondly, that it had to be disturbed. In the matter, you found you held that there was that a letter written for someone not to trespass on the property equated to spoliation. Is there a specific legal precedent that you looked at to rely on for that that finding, or what persuaded you to make such a finding, which of course was overturned later by the PCA?
Unfortunately, I won't be able to pinpoint the law that, or the specific authority that influenced me, because if you can look at that case, I think I mentioned in one of the decisions that were overturned, it's a case that I dealt with a long time ago. I can't remember that, except to say that in that matter, there was sort of no precedence in as far as spoliation, whereby a claim of spoliation was done through a letter of demand. The issue the main issue there was a letter of demand. But I can't pinpoint, I don't have it here before me, and I can't pinpoint what authorities led me to that decision. I wanted to just check the date of that judgment, question 3. It's a very old judgment that I dealt with, I think, when I was even new at it's Bishop. Yeah, unfortunately, I don't have, but it's a very old one. It's a very, although it came very, very late to the Supreme Court of Appeal, 2021. Am I allowed to check the citation on my phone? Because I think it should be there on Safli to check when did I deliver it. It's some time, long time ago.
Do we need her to check the citation online, Commissioner Bernard? Is it necessary?
I can't remember. I can't remember everything what I dealt with, except that I can remember, as you are talking now, that it dealt with a letter of demand as a spoliation.
It's just that's exactly the point. I don't think it's any appreciate it. I think the question is just how did you arrive? You know, what brought you around to find that a letter written about somebody possessing land actually amounted to them being disturbed in their peaceful possession of that land. Just that extension of the law that is somewhat strange. Perhaps I would like to clarify.
I can't hear properly, but if I heard you, you'll correct me. I can remember that little part of the facts. But remember, there will be council who are making submissions based on, yes, authorities perhaps, that will have probably persuaded me, but I can't remember them now. It's an old case.
All right. Thank you, DCJ. There's nothing further from me.
Any further questions from the virtual platform? I see a hand. All right. Judge Kwele, thank you so much for your time. It looks like we have reached the end of your interview. You're excused.
Thank you very much, Justice Maya.
Well, colleagues, while Judge Kwele is collecting her things for the sake of time, the hotel is ready to serve us our lunch now, but because we are running way late, I would propose that we gulp our food down as fast as we can, maybe take 30 minutes and come back. We still have 5 candidates to interview, and we are well into the afternoon. It's 3 now. So shall we take lunch now, or do you want to deal with? All right. It's 14:53. We'll come back at 1:30 on the dot. In fact, 1:30 on the dot, we must start, not be working our way back here. housekeeping matters and if I'm going candidates. Yeah, let's leave it. Just want to, I'm setting a timer. Good afternoon, Judge Hussein.
Good afternoon, Justice Brown.
How are you?
I'm fine, thank you.
Good. First, I must apologize that we kept you waiting for so long. Circumstances beyond our control, but do forgive us, please.
Fine, thank you.
Let's get right to it. You were you born in the Eastern Cape?
Yes, in
Born, bred, studied there, worked there, work there.
I studied at the University of Cape Town after school, but otherwise born and bred in Gqeberha.
Yes. What did you study at the University of Cape Town?
I did a BA and then subsequently an LLB.
All right. I see that you started out as an article clerk, but then decided to join the bar.
Yes, I did. I didn't do a full period of clerkship. Started off beginning of '89, and then in May of 1990, I went to the bar to do pupillage.
Yeah. You were at the bar from 1990 until 2011.
Yes.
But then you interposed and worked with the Truth and Reconciliation Commission for, was it a year or 2 years?
It was just under 2 years, from April 1996 till the end of 97.
What exactly did you do with the TRC?
I beg your pardon?
What did you do with the TRC?
Oh, I'm sorry, Justice Meyer. I was the director of the investigation unit, the national director. I worked under the commissioner who was in charge.
You are appointed at the Eastern Cape Division. That's where you started out and that's where you still are, right?
Yes, that's correct.
Okay, since 2012?
Yes.
Okay. When did you start acting at the SCA? Just remind me.
I was appointed from the 1st of June 2020 until the end of May 2021. And then again from the 1st of June of this year, and my appointment is until the 30th of November of this year.
So you are there now?
Correct.
All right. How many terms is that?
I've now completed
In total?
five terms. The next one will be the 6th.
All right. How have you found the experience? Stimulating, I hope?
I have found it very stimulating. I've enjoyed it enormously. The first year was challenging, as you would know, because everything was done virtually. And so we weren't based at the court. Although in the May of 2021, I did go to the court and operated virtually there. But it was very stimulating and very enjoyable. Yeah.
Speaking about virtual hearings, I'm going to make a disclosure. You and Judge President Shenaz Mir at the LCC are the reason the SA was actually able to pull that off, be able to, you convinced me that it was possible to conduct hearings virtually because no one had done it. And then suddenly we heard that there was a judge who had just done motion court of all proceedings on the virtual platform. And then I called you and I did not know you from a bar of soap and you were brimming with all these ideas. And through your help, our court was able to carry on uninterrupted. Thank you for that. I don't think I've ever thanked you.
So it was a pleasure. I'm glad I could be of help.
Right. How many judgments have you written at the SCA?
I think it's 11, I think, from the previous acting stint. And from this term, there are a few that are at conference stage.
I see that you have a few articles, published articles under your belt.
Yes, I have.
All right. All right, I think that's it from me. I'll let my colleagues loose upon you.
Thank you. Thank you, Justice Mahar.
Colleagues, do you have questions for this candidate? I've only seen up to Commissioner Nyambi. Pillay. Any other hands? Okay. Commissioner Moiman?
Thank you, Deputy Chief Justice. Good afternoon.
Good
Justice
afternoon.
Susan. Just one question from my side. How do you balance transformative justice and good governance displayed through one of your judgment that you refer to as part of your contribution to jurisprudence, Mazozo versus the Minister of Basic Education, against sometimes an outcry that there is judicial activism and judicial overreach premise on the assertion that when the judiciary set aside either executive decision or a legislative decision, it blurs the separation of powers. Thank you, Justice Susan. Thank you, Deputy Chief Justice.
Yes, thank you, Commissioner. I think the Constitution requires transformative justice, and that means that the courts are required to act in accordance with the constitutional imperative. So when one's dealing, as in that instance, with the right to basic education, firstly, the interpretation of that right is to be informed by the concepts broadly of transformative justice. But one's ever mindful of the fact that the courts are not there to either legislate or to determine broad policy questions that fall within the prerogative of the executive. In that particular instance, it involved the assertion of the right to basic education, the provision of school furniture, and so what one was concerned with was how the executive government departments responsible for ensuring that those rights are met could do so. There certainly is scope always to place, in this case, the executive on terms, and I think that was the end result of that case. But it's a constant juggling act, and there are no easy or definitive answers one way or the other. They're usually driven by the facts of the case and the particular circumstances that one's dealing with.
Thank you, Justice Susan. Thank you, Deputy Chief Justice.
Mic is off. Commissioner Nyambi, it's your turn.
Thanks, DCJ. Afternoon, Judge Hussein. One question from my side. What are the three attributes of a good judge, especially SCA, probably if we can share with us those that you think you have.
Thank you. Thank you, Commissioner. I would think one of the first for me would be a commitment to hard work, to engaging with the material that's presented. And I don't mean that flippantly. That hard work requires a level of engagement with the case at a particular depth. So that's one of the first things, that one's got to be prepared to really get to grips with the issues and the material that comes before you. I think one of the second attributes is being in a position where you respect your colleagues who are on the panel with you, that you're open to the thinking that emerges in the debate with counsel and with your colleagues, and that you maintain a sense of open and fair engagement with your colleagues. The third is that you are, even if you are not engaged or haven't given the task of writing the judgment, that you are, once the conference has been determined and more or less the outcome is decided and the scribe is busy working on it, that you prepare to offer whatever assistance through the research that you have done in preparation for that. I think those are three things that make it, that make the task of sitting on a panel at the level of the ACA that much easier. Of course, there are other attributes that one should have, but I think from a working point of view, those are the sorts of things that you need to bring to bear.
Thank you, Judge Hussein. Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Jess?
Justice Hussein, notwithstanding the fact that the jurisdiction of the Constitutional Court was extended, yes, but the SCA remains the apex court. It must develop common law. It must settle precedent. My question is, in terms of your own experience, are you a judge that is ready for the SCA?
Yes. Thank you, Commissioner Nochezi. I believe that I am ready, both in practice and in the time that I've spent on the bench. I've had the benefit of exposure to quite a broad range of work in areas where one would expect that those types of questions come before the Supreme Court of Appeal. I've dealt, for example, with shipping law. I've dealt with environmental law, some intellectual property matters. I have had exposure to local government and to planning law. I've obviously, as a High Court judge, dealt with the areas that are more regulated by the common law contract and delict and the like. Although I claim no particular expertise in any of those broad areas, I believe that the exposure means that I'm able to deal with those matters. I can come to grips with them. You're quite right that of course the Constitutional Court is the apex court. But the Supreme Court of Appeal has a very particular responsibility in the work that it does, I believe. in ensuring that the broader questions of precedent setting in the wide sweep of the law occurs in a way that is consonant with the constitutional imperatives, and that it can supplement the work of the Constitutional Court. And I would think that from the experience that I've had and my background, that I am able to fulfill that task.
Lastly, I think this is my last question. I've counted not less than 13 judgments you have returned in the SCA. I'm not too sure, and
Thank you.
I was unable to count further on your reported judgment as the judge of the High Court. There are many. You agree with me, or you don't, on this one? My take, or what I want to suggest to you, is that the test or the standard expected of a person who is a candidate for a High Court, where you look onto the potential of the candidate, and a person who is expected or was applying for the SCA, the standard should be different. That person must be an all-rounded judge, must be complete, and that can only be assessed through the judgments that have, that he or she has penned down. Would you agree with me? That's my last question.
Yes. No, I think that that's a fair comment. The criteria for initial judicial appointment is, I would imagine, different to that which would apply when one is appointing to a higher court. And at the end of the day, the best indicator of the capacity of a candidate is from the judgments that have been written. That's one of the most obvious, because that's where judges are ultimately accountable. So I would agree with that assessment.
Okay. Thank you, Commissioner Matthews. Commissioner Pillay?
Thank you, DCJ. Good afternoon, Judge Goosen.
Good afternoon.
Judge Goosen, I really just have one question, and it's in relation to your judgment in the Serowitz matter.
Yes.
Now, that's a matter where Ms. Serowitz was poor and unemployed. She was the head of a household. She had in her household her daughter and granddaughter. She entered into a deed of sale for 40,000 rand with Mr. Posthumous. And she borrowed the money and paid the 40,000 rand over. And 4 years after he received the money, Mr. Posthumous was sequestrated.
Yes.
And she never got the property transferred into her name. I think she approached the High Court for assistance, and her real issue was how to get the trustees of the insolvent estate to transfer the property into her name. And what she really wanted to do was to compel the transfer of the property into her name. And I think it came before you and you dismissed the application. And subsequently, and I accept that at this stage, her case was amended slightly in the sense that she relied on some constitutional rights and applied to the Constitutional Court. She appealed against your judgment to the Constitutional Court.
Correct.
What struck me, Judge Goosen, was some of the sentiments that came out of the Constitutional Court judgment. And I just want to read just 2 lines of the judgment to you. The first is in the majority decision of the then Chief Justice. He says, this case is about homelessness and vulnerability. One of the many painful and demeaning experiences that the overwhelming majority of our people had to contend with during the apartheid era was not having a place they could truly call a home, and their vulnerability to the system's over-abiding readiness to evict arbitrarily. And then if one goes to the minority judgment, it's a judgment of Judge Cameron, you see a similar refrain, and what Judge Cameron says is the following. He says, it would be a disgrace to the law if there was no answer to Ms. Sarowitz's plight. The main judgment explains that the essence of a claim, etc., and that a case like this demands a solution from the law. Now, I just wanted to get a sense whether the social justice element Was that plain to you when you heard the matter, and how it is that you responded to that?
Yes. Well, I think that the case, when it was argued before me, was pursued on a fairly narrow basis. I think in retrospect, I think there's no doubt that it's a matter involving an instance of a vulnerable person facing the possibility of eviction in the way in which it played itself out. But questions around the constitutionality and a direct challenge to Section 21 of the Alienation of Land Act wasn't a matter that came before me. The case, when it came before the Constitutional Court, was in fact quite a different case. Not only was the evidence, there was evidence presented at an appeal level, and the matter was prosecuted on a different basis. I accept, obviously, the result, and I think what the minority judgment points out is that the solution was not necessarily as easy a one, although clearly the majority, the solution was to read into Section 21 certain phrases, to read into the legislation a definition of a vulnerable person and the like. And the majority would have come to a different conclusion. The minority would have come to a different conclusion. I think correctly, it ultimately was about the position of a vulnerable person. But if you take a decision, and ultimately the Constitutional Court points out that you are wrong in that decision, that's an opportunity to learn and appreciate the basis. I had just recently another instance where the Constitutional Court came to a different conclusion to one that I came to in the Supreme Court of Appeal in the matter of Grobler versus Phillips. Obviously the Constitutional Court is correct. That's the position one adopts. But yes, no, I appreciate that what the case was about ultimately was how the Constitutional Court conceived it.
Thank you, DCJ.
President Pete.
Thank you, Deputy Chief Justice. Good afternoon, Judge Hussain.
Good afternoon, Acting President.
Earlier, you did mention that in every case where you sit, even in instances where the judgment has not been allocated to you, you assist whenever you can whoever is the scribe.
Yes.
And in your experience at the court, has that kindness when you are described been reciprocated by the other members of the bench?
My experience is yes. Generally, when the panel, is deliberated on the at conference, and you have now go off and start writing your judgment, if there is particular assistance that any one of the panel feels that they can offer, they would do so. That's certainly been my experience.
Yes. One of the comments from Nadel,
yes,
where they say the SA currently has 4 white men, and we're not certain if his appointment, he is being a reference to you, will not lead to over-representation on the SCA bench. How do you respond to that?
I think that the figure is incorrect. There are, in fact, only currently 3 white males serving as permanent judges on the bench of the SCA. And that position, of course, is one that is likely to shift and change over the course of the next short while. I don't believe that appointing me at this stage would result in an overrepresentation. If I were to be appointed, then there would be 4 white males on the bench presently.
You are, of course, aware that there are many factors that must be carefully considered by the Commission when it comes to the appointment of judges, especially to a national appellate court like the SCA. You know, apart from experience, industry, scholarship, there are also the constitutional requirements spelled out. I think it's section 174.
Yes.
About gender and race representativity.
Yes.
Considering that the 5 vacancies that we currently have came about because 3 black judges retired, 1 black judge was elevated, and of course 1 white judge who was discharged from active service.
Yes.
What factors do you think or would you like the Commission to take into account insofar as you are concerned that you think should tip the scales in your favor, considering that there are 2 other white candidates, male candidates,
yes,
and 2 white female candidates?
Yes. Thank you, Justice Petse. I accept that there would be, because of the constitutional requirement for demographic representativity, if you like, and that imperative remains, that there would be limited space within the 5 vacancies that are available. I would suggest that my experience, the breadth of that experience, the extensive commitment to transformation processes, both at the in practice and on the bench, that those would tip the scale. And I say the latter because I think if you look carefully at my CV and the type of work that I've done, I have the institution is what needs to be strengthened, and I have endeavored to do so through a process of training, mentoring, and, if you like, creating opportunities for people to be of their best within the institution. The commitment to the institution has meant that I do like to think not just about the work that I do as a judge. I try to do that to the very best of my ability. But I do constantly think about what the judiciary requires. And that has been... oh dear.
I'm sorry, I forgot to warn you. We were told that there was going to be load shedding around this time, but apparently it takes just about 1 minute to kick in. So let's just hold tight. It will be back on now.
Sorry, yeah. Shall I hold on, I believe?
Yes, please. Oh, there you go.
Okay.
Carry on, please.
Yes, thank you. Thank you, Madam Chairperson. Yes, I was saying that that...
Oh, I'm sorry, Justice Hussain. I think the online colleagues are not connected. Can you just check that?
I can hear you. Okay.
They're not connected.
Well, if they can hear us, let's carry on. They don't have to see us.
Okay, thank you. Yes, as I was saying in answer to the question, Justice Pett said that I think what you'll find from my engagement in the profession and my involvement in training and mentoring and activities of that, that I believe in the strengthening, as far as one can, as an individual, the institution, whether it's in the profession or, in this case now, the judiciary. So I do think about the judiciary constantly, about it, rather than not just only the work that I have to do. It's that process that took me into working, for example, with the judge president of my division around case management, took me during the period in COVID that Justice Meyer referred to think about what it is that we needed to do, and do quite urgently, around facilitating the functioning of the courts. So it's that broader commitment to the institution, I think, which is an additional factor that one can take into account.
Thank you, Judge Hussain. Thank you, DCJ. This is where I leave it.
Commissioner Marumachai?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
I do note the fact that you stated at the outset that you are not an expert of all these, but you had exposure to them.
Yes.
And when I went through your CV, I realized that one of the areas where you have produced a judgment is actually the interaction or the intersection between pension law and family law. The case of Fritz, I'm not sure if you still remember that case. Fritz versus Fund SA.
Yes,
Work umbrella fund.
Yes.
Yeah, you still remember that case?
I do, yes.
I just want us to deal with that case. At the time when this case is, at the time when you delivered this case, there was a Supreme Court of Appeal case that was penned by President Meyer at the time, Krugel versus Eskom. I'm not sure if you are aware of that. I'm just surprised that based on the facts of this case, that particular judgment was not Because I see that your judgment was delivered a year later, because that judgment came around about 2011.
I see.
And your judgment, if I can see here, it came around about 2012. And of course, you referred to some of the judgments that are important, Siphelele and Maharaj. And we know from Peter's acting president at the time in Daba that Siphelele was wrongly decided. I just want to understand, when you are following precedent, and the extent to which you do your research, I know that there might be perhaps maybe the council before you might not have argued or referred you to a particular judgment, because I think there's a particular paragraph in your judgment that really is answered by paragraph 11 of President Maya at the time's judgment. Okay. I just want to understand, when you go through judgment writing and the extent of your research, okay, and how you deal with precedent.
All right. No, thank you. One is you never rely entirely on the work that is presented to you by counsel. You have to do your own work. There's no doubt. I don't recall precisely. Almost certainly, if it was not referred to me in argument. If it had been, then I would have dealt with it. No doubt. But there are circumstances, I think, particularly in the High Court, as a judge, when you're working under pressure, that you may well miss a more recent matter. I have had often matters argued before me where quite eminent counsel have argued a matter where they haven't referred to the most recent authority, but where I've been able to find it. If in this instance I missed it, then I must have missed it. I haven't looked again at the case nor considered the judgment, but I accept that must happen occasionally. Yes.
No. I think that is fair enough.
Thank
I just want to ask you then, in relation to the law that was dealt with in that particular case.
Yes.
Obviously, in that case, you had a woman who came and wanted to claim what she thought was a pension interest from the husband at the time. But at least from the facts, it appears as if at the time of the divorce, the husband was not a member of a pension fund. And you proceeded, of course, to correctly dismiss the application. But my point is not there. I just want to understand, in relation to the way in which the pension interest is dealt with in this country and the law relating to it, Section 7, Subsection 7 of the Divorce Act, Section 7, Subsection 8 of the Divorce Act, and how it intersect with the Pension Funds Act. Do you, in your view, think that perhaps women, in particular, in most instances during divorces, are actually being prejudiced when these matters are dealt with? Do you think that the courts are dealing with these cases in the manner in which they should be dealing with them? Thank you.
Thank you. I would say that the scope for prejudice faced by women is significant. I'm not sure that I have, if you like, available to me the means to answer the question as to whether the courts are or are not applying this correctly. That would require a careful look at a whole range of judgments on the issue and an assessment of that. I've not undertaken that exercise. But I would certainly be, I think, conscious of the fact that when it comes to pension interests and intersecting with the position that women find themselves in upon divorce, that there is a great deal of scope for prejudice. Partly that's the reason why the legislature has sought to deal with it in the manner in which it has.
Thank you. My last question, Deputy Chief Justice. Have you ever written a judgment in the Supreme Court of Appeal, and that judgment you receive comments from your colleagues to the extent that it changes the entire judgment, and then the final product, it becomes different from the initial product, and then all the colleagues who are part of the panel agree with you and you release a unanimous judgment? Is that the practice generally? where in that court, people will be making comments to influence the judgment, and ultimately it will be a different judgment.
Yes. Thank you. Well, it's not so much about comments to influence the judgment. The process would be that after the hearing, there would be a conference of the judges, and each of the judges would present how they would see and understand the case and what result they would envisage for the case. So at that, if you like, early conference stage, there would already be an exchange of views that would give the scribe, the person who's to write, an idea of whether the judgment that she or he is going to write is one that will be either a minority or a majority view. It certainly happens that in the process following a conference, further reflection and research and consideration may result in either the scribe or, for that matter, any one of the other judges changing a view that they might have had at the initial conference.
Thank you very much.
Yeah.
Thank you.
The alarm you just had go off, colleagues, was the 40 minutes he was allocated running out. So let's please keep that in mind going forward. Commissioner Matolo-Lebu.
Thank you, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
No, mine is just a simple one. I see you have written a lot of articles about transformation. The one that interested me is the ethics as a driver of transformation in the legal profession. And I just want to hear your view, because for me, we are still talking about transformation.
Yeah.
And every day, and we are stagnating, actually, as far as I'm concerned, especially in the bar councils. What do you think should be done, actually, to transform the bar council?
Thank you, Commissioner. I'm not sure that I can comment directly on what should be done in the Bar Council. I'm quite removed from that. I'm certainly conscious of the fact that a lot more needs to be done within the profession, at the bar, or for that matter, amongst attorneys' practices to foster transformation, and that we're nowhere near where, if you like, we need to be. So I accept that entirely. The article, the focus was really on how we could marshal a deeper understanding of the ethical obligations of practitioners, and use that, if you like, as a driver for fostering transformation, broad transformation within the profession. As to what needs to be done broadly at the level of the bar, given that that was my professional background, I think high levels of support for new entrants coming in, intensified mentoring and training programs to ensure that new entrants, particularly black and women entrants, get the opportunities to build practices to allow them to sustain themselves at the bar. I think that's a critical element.
Okay, thank you, Deputy Chief Justice.
Thank you, Commissioner. JP Mlambo.
Thank you very much, DCJ. Good afternoon, Judge Clausen.
Good afternoon, JP Mlambo.
I just need to make one comment first before I ask a clarification question. I want to thank you. I mean, I'm here, I represent other heads of courts. I want to thank you for the instrumentality you introduce in assisting your head of court in the Eastern Cape, especially on the judicial case management front, and the assistance you gave to the DCJ when she was heading the SCA in them moving over virtually. as heads of courts, we welcome assistance like that from judges. So I want to thank you for that.
Thank you.
My question relates to what Commissioner Nojesi asked you. So I'm not sure if I heard what your response was. He posed a question to you that the SCA is an apex court when it comes to the common law. What was your response to that statement?
Thank you, JPM Lumbo. I think that what I did indicate is that the Constitutional Court is the apex court, and it is the apex court in relation to all of those matters, including the development of the common law, because that development occurs obviously in the context of what the Constitution requires.
Okay, thank you.
But what I suggested was that the SCA needs to and must play an important role in providing support for the process at the Constitutional Court level.
No, thank you very much.
Thank you.
Thank you, DCJ.
Do we have, Commissioner Rikis? You want a second bite?
Just on this, I actually, I'm not sure whether I did qualify that.
Yes.
Every matter now, the SCA, because it has extended, I mean the SCC, it has extended jurisdiction, where, you know, I've raised the constitutional issue, public interest and all those things.
Yes.
But I explained the role of the constitutional, of the SCA, not necessarily saying that it is the final court. I just want to correct if I'm understood wrong in that regard.
Yes. Yes, thank you.
Thank you, Commissioner. Are there any questions from the virtual platform? Commissioner Bernard?
Thank you, DCJ. Judge Goosen, just one, and it's on the matter you referred to, the Grobler versus Phillips.
Yes.
You sort of alluded to the fact that you accept the Constitutional Court position is correct. My question to you is, what was the difference in approach? You remember that the magistrate had ordered eviction and then it went through the High Court and the SCA, eventually in the Constitutional Court again ordered the eviction. What was the difference in the approach, and where did the SCA and the Cape High Court go wrong?
Well, I think that the difference between the two judgments is quite a narrow difference. The Constitutional Court, as I understand its judgment, suggested that I had, for the SCA, perhaps paid undue weight or given undue weight to the expressed wishes of Mrs. Phillips, and that was wished to remain. That was a factor that we took into account at the SCA, and the Constitutional Court placed that in perspective and came to a different result. So there's not a widely divergent difference in approach, as I understand it.
Thank you very much.
Thank you.
Commissioner Bredenbach, you appeared on screen for the first time today. Do you have a question?
It's actually the second time today. Thank you. My question has been asked already, so I'm covered. Thank you.
Thank you. Justice Goosen, it does appear that we have run out of questions for you. We've reached the end of your interview. Thank you so much for making the time to join us this afternoon. You're excused. Go well.
Thank you very much for having me. Thank you. Should I put this on?
Are you ready, Judge
Yes,
Kun? All right.
Yes, I am.
Good
Sorry, I didn't.
afternoon.
Thank
how,
you, Judge.
How are you?
I'm very well, thank you, Judge Meyer. Yourself?
I'm fine, thanks. It's good to see you after a long time.
Thank you.
You were interviewed by this commission not so long ago, and we have the record. It was a thorough interview, so I'm not going to lead you on your list of achievements. All I will ask is, what have you been doing with yourself since then that you think might warrant inclusion in your CV?
Judge Meyer, it was in fact on the 14th of April 2021. Since then, I've just been doing my normal duties in the KwaZulu-Natal court. I had been asked, and that's probably what you might be referring to, prior to my previous interview, by the Deputy Judge President to preside in the matter of the state versus former President Zuma. And I'm the judge in that matter. And I think the rest is an issue of public record, that a plea has been raised, which I dealt with, and then also applications for leave to appeal thereafter, petitions to the Supreme Court of Appeal, a reconsideration application by yourself, and then the matter has been referred to an application was made to the Constitutional Court, and I gather, although I haven't seen it yet, that a judgment or order was issued last, I think, Wednesday, dealing with that, but I haven't seen it, so I wouldn't like to simply quote on what I've read from the press. But that has been the, if you like, the main sort of issue of public interest, I suppose, that I've been involved in, apart from various other duties in KwaZulu-Natal.
All right. Oh, there is just one other aspect. You have made a submission in your application form on the rather unfortunate exchange you had with former Chief Justice Mogoeng during the interview we just spoke about. I don't know if you'd like an opportunity to set the record straight from your side now that you are here. If you don't wish to do that, it
Yes.
is your prerogative.
Judge Meyer, maybe I should, in the interest just of transparency and fullness, say that I consider it to be a very unfortunate incident. I was very saddened, and when I left the venue, felt gutted by the criticisms that had been expressed of me. I had been forewarned with documentation which I circulated with my covering letter to the Judicial Service Commission for this interview today. I provided those documents which alerted me to the fact that I was going to be questioned on cost-cutting measures which were sought to have been introduced by the Circular 15 of 2016. And when I answered those, that being the issue on which I prepared, I was told that that was dealing with the merits, and that the former Chief Justice's concerns related to the manner in which he said I addressed him. And he then also went further to say that he wondered how I ever was made a judge, how I dealt with litigants and people who appear before me. And because I'd been forewarned to deal with the issue of cost-cutting measures, I did not have the transcript of the particular meeting to which he referred. I didn't have a formal version thereof transcribed and certified by a transcriber. If I had been forewarned about it, then I would have produced that at the hearing, which was or the interview on the 14th of April 2021. I have now, and I hope that it's been circulated to all commissioners, obtained that transcript. It is circulated with a covering letter. I have also circulated the audio clip of that entire judges' meeting, because fortunately that meeting had been recorded. I was not aware of it at the time that it was recorded, but it was. And I don't want to spend negative energy on this issue. It's something that happened. I think it was unjustified with respect, but commissioners can look at it. They can read the transcript of that judges' meeting, which was said to have caused so much offense. They can listen to the recording, and if they do or would be so inclined, I think they would have picked up that there was no raising of voices or anything. I was speaking as one of the senior members of the KwaZulu-Natal bench as I'm speaking at the moment. But as I say, it happened. I was gutted by what was said. If litigants or people in the legal profession Google my name, they come up with that interview and the lashing that I received. That is going to be a historical fact that's going to remain with me for the rest of my life. But we must move on. I don't want to harp back on it. I think there are more important things. I see my role still as making a contribution to the judiciary, to jurisprudence in this country, hopefully, and I don't want to be sidetracked by what happened. It's behind me. You know, so many people, when I walked out of that venue, my phone was ringing non-stop, and judges from the Constitutional Court to the Supreme Court of Appeal to other provinces were all phoning me and saying, "But what is he talking about? We know you." And practitioners were saying, "You must sue for defamation." You know, where's that going to get us? That's been my attitude since then. I don't think that will be in the interest of the judiciary. But please, I don't really want to dwell on it anymore. It's a very, very unpleasant episode in my life. It's something that I relive quite often in the early hours of the morning. I won't deny it, but I suppose it comes with the territory. And thank you for the opportunity to comment on it. I'm not wanting to score points out of it or anything like that. I'm simply wanting to put the record straight, and I'm happy to be judged by what commissioners think of the transcript and the recording that I've circulated. Thank you.
Thank you very much, Judge Kun, for that explanation. Well, for what it may be worth, I do want to place it on record that those of you who worked with you at the SCA did not know, do not know the person that was described here during those proceedings. Throughout your acting stint at the Supreme Court of Appeal, you always behave impeccably as any good judge would. So, thank you. I will hand over to my colleagues if they have any questions for you. Questions, colleagues? Commissioner Nyambi? President Petse, Commissioner Nyambi.
Well, thanks, DCJ. Afternoon, Judge Kun.
Good afternoon.
From the last time you were interviewed, as you might have reflected or gone through what happened then, besides the issue that you have touched, any other thing that you think with hindsight you might have put it differently or you want to bring to attention in terms of reflection of the past interviews, besides the issue of that unfortunate incident that we must seriously consider this time around?
No, I don't think there's anything. If you read the transcript of the last interview, the one of the 14th of April, I am very happy with the way that questions were posed to me. I was very happy with what was being sought to be explored. The transcript is not a perfect transcript. There are some errors, but I don't think I could have wished for a different interview up to the point near the end when Chief Justice Mogoeng then took over the questioning. Is that what you're wanting me to deal with?
No, it was about any other thing that is significant as we have done the reflection about the past interview, besides the unfortunate incident that you might want to bring to our attention now, so that we can seriously consider you as a possible candidate to go to the CA.
I see. Well, since the last interview, obviously I have now spent another 18 months as a puisne judge. At the end of this month, 31st of October, 2022, I will complete 16 years as a puisne judge. I've always enjoyed the study of law. There was a bit of a hiccup with the incident that occurred, and it made me considering all kinds of options, possibly even leaving the judiciary altogether, and employing my skills to the extent that I have them elsewhere. But I enjoy being a judge. I have, however, reached the point, but that isn't really something new. It also prevailed in April of 2021, that I think I've grown to a stage where I'm looking for new challenges, and that's really why I'm looking at the position on the Supreme Court of Appeal. As an appeal court, I think I've got the experience that I can contribute. I can contribute the other issues that are detailed in the transcript of the previous interview. And it's going to be, although it might sound self-satisfying, it isn't. Well, I suppose it is. But I foresee for myself more professional growth in an appeal court setting where I've been in a trial court setting for 16 years. And I'm now 63. My exit date will be the 14th of September 2029. So that gives me just, 7 years.
Thanks. My last question, Judge Good. What event or incident or judgment in the recent years will rank highest in your view as having contributed the most in the strengthening or development of the South African jurisprudence?
Sure, that's quite a, if I have to cast my mind back, it's perhaps not in recent years, and it's perhaps not a judgment so much that I gave, but a judgment that I was involved in, and from which there have been interesting developments. And it's in the list of judgments that I refer to, or the cases. It is the one of ShopRite Checkers and Everfresh Market, Virginia. Now, I'm a little bit hesitant to claim any credit for it, because, it's that judgment, and then also the one in KwaZulu-Natal Joint Liaison Committee versus the MEC of the Department of Education. And I'm hesitant to claim it as a contribution on my part, because it started off as a fairly simple issue before me, presented as a contractual claim as to what is meant by the word approximate. And I had made certain findings that it was too vague to be enforced at a purely contractual level, and it met with a similar fate at the Supreme Court of Appeal level. But then it had made its way to the Constitutional Court. And the Constitutional Court then dealt with the issue. The majority judgment, separate concurring, majority judgment by Cameron J., separate concurring judgment by Fruneman J. My approach had been one more consistent with what Zondo, then J., Mogoeng CJ and also Jafta J had opined or concluded. But the point that I'm wanting to make is, although it was presented as a contractual matter, how it ended up was that it was treated as a public law matter, although it wasn't a review, which was quite a step forward. And there's a very interesting article, and that's why I say I view this as quite an important or an interesting development, because there was a very interesting article by a contemporary of mine at university, that's Professor Hoekstra, called The Enforcement of an Official Promise, Form, Substance and the Constitutional Court, where she discusses the judgment in KwaZulu-Natal Joint Liaison Committee and then also contrasts it to the judgment in Kurland. Now, the interest arises from the fact, for me, that in KwaZulu-Natal Joint Liaison Committee, Cameron and Fruneman were really prepared to go outside the pleadings to achieve a result which they believe constitutionally was required. Whereas in the Kurland matter, they were more insistent, because they form part of the opposite side. They were more insistent that if something wasn't claimed by way of pleadings, that one couldn't deal with it. In the context of what we're discussing at the moment, my present statement to you is probably too superficial to perhaps emphasize the point that I'm wanting to make. I don't want to go into the facts of each case because we have limited time, but it's that kind of proactiveness, if you like, not being bound by pleadings, which is quite a debate, I think, in our law, which will need to be addressed. Obviously, I hear and I live with and I deal and I unreservedly accept what the Constitutional Court had decided, for example, in KwaZulu-Natal Joint Liaison Committee. But it's an interesting point, this, of to what extent in future litigation the pleadings are always going to be taken as the be-all and end-all of what the parameters of the parties' dispute would be. In KwaZulu-Natal Joint Liaison Committee, you might recall that the parties were encouraged, directed to negotiate, to try and agree on what is meant by an approximate value, and failing such agreement, the matter had to be referred back to the trial court, me. And I am not sure how I would have resolved it, but I think fortunately it was settled.
Thank you, Judge Kuhn. Thank you, DCJ.
Thank you, Commissioner Nyembe. President Pete.
Thank you, DCJ. Good afternoon, Judge Kuhn.
Good afternoon, Judge Pete.
From the feedback that we received from legal bodies, there is one from the Black Lawyers Association, which would have been furnished to you in the ordinary course.
Yes.
The last paragraph says, his judgments, that being a reference to you, do not demonstrate a deeper understanding of the constitutional law, which we believe is needed at the SCA. I raise that with you in the context of the judgment of Mahlangu versus the Minister of Police, where your judgment that the SCA was overturned by the Court. And the proposition that I want to put to you is that that case implicated two important rights entrenched in the Bill of Rights, that is personal freedom, right to be free from all forms of violence, and not to be tortured in any way, which were lost on you when you wrote your judgment, because the High Court had found that Mr. Mahlangu and the other appellant were tortured by the police to extract a confession from them. That confession was used by the police to oppose bail on the basis that they had a conclusive case against the appellants who were charged with murder, resulting in them being detained for up to 10 months. And the effect of your judgment overturned by the Concord was that they had no claim against the Minister of Police beyond 7 days, the initial 7 days of their detention. Would you like to respond to that?
Yes, thank you. Obviously, I've seen the statement in the, I think it's the second letter from the BLA. It didn't identify any particular judgment, so I wasn't able to really make much of it. But I'll deal with the Mahlangu judgment. The Mahlangu judgment, you obviously recall because you were the senior presiding judge on that matter. It had come from the trial court. It went where the decision was given. It went to a full court, Colopin J and two others I can't remember, that also denied, albeit for different reasons, a remedy. So when we dealt with it, it was really the third court that was dealing with it. 4 judges already previously effectively haven't denied him that right or the compensation. The SCA was split. I wrote the judgment, Kachalia JA and Dolamo AJA concurring in my judgment, and Van der Merwe JA wrote a separate judgment, and you wrote also a separate dissenting judgment. The issue of, let me say also that I unreservedly accept that there are constitutional rights involved, but the matter really turned, and I think it was following a judgment of the I think it was Kruger, if I remember correctly, but the issue became one of causation. I unreservedly also accept in that matter there was the issue of torture, and I would not deny a remedy to the person subject to the torture in a claim against his torturers, the police and the Minister of Police. What my concern was, and that of the judges who, and I can only speak for them, who concurred with my judgment, was the question of causation thereafter. That a limit must be reached on where the liability of the Minister of Police would terminate. Doesn't mean that after that there's not a remedy, for example, against the Minister of Justice. You will also recall that one of the issues arising in that matter was the problems that are experienced with so-called reception courts on bail being granted. So in a nutshell, if I can answer it, or if I can oversimplify it, and please forgive me if I do oversimplify it, torture, the detention by the police, the initial lying off that there's a confession, up to that stage, clearly there's an action against the police. I think what I was trying to grapple with, and that I was trying to deal with in my judgment, was the question of causation. That when a point is reached where there's a court that should entertain and adjudicate a bail application, that the liability does not lie with the Minister of police anymore. I accept, however, that on that causation element, certainly the Constitutional Court came to a different conclusion, and I unreservedly accept that. But I certainly did not make light of, and I now cannot recall, but I think, no, we might have left it out. No, I think we did include it. There was in fact a very useful reference to the treatise on, international treatise on torture being applied in matters where accused are being detained in custody, which Mr. Justice Kachalia brought to my attention. And either it was part of the draft that I prepared and remained there, or I might have taken it out. But if I may just refer to that fact that I was very alive to those dangers, and I certainly am alive to the constitutional value of it, and I would certainly, if there was any claim for pain and suffering, loss of amenities, contumelia, etc., flowing from the torture, that would clearly found an action for damages against the police.
Well, the claim was about unlawful detention.
Yes.
And you found against the appellant.
Yes.
And the minority judgments came to a different conclusion.
Yes, that is correct. It was on the question of who caused that further detention. Was there an interruption of the initial cause caused by the arrest by the police, or should there have been a determined judgment being issued by a court of law, and not just these detention courts, no, not reception courts, where matters are simply adjourned.
You are aware, of course, that there are many factors that the Commission should carefully consider when it comes to the appointment of judges, and bearing the constitutional imperative in terms of Section 174(2) to promote, as far as it is possible, a bench that is broadly representative of gender and race. What factors would you like the Commission to take into account in relation to you that you think should tip the scales in your favor, bearing in mind that we have 5 white candidates, 3 males and 2 females?
Yes, that constitutional imperative is obviously, it's always a difficult issue. It is something which this Commission must address. I am obviously a white male. That is a fact. 174(2), as I said during my previous interview, I do not think introduces a sort of an employment equity type analysis at all costs. From the permanent appointments that I understand on the SCA at the moment, I think there are 21. That's the figure that was mentioned in the report backs, of whom 11 are women. And I was told earlier today that of the 10 males, 3 are white And then obviously you've just referred to the statistics on the current applicants that you are interviewing for these 5 positions. I cannot get around the reality that I'm a male and that I'm a white male, and I don't profess or try to do so. I certainly, however, try to give expression to the sentiments and the thinking, I think, behind 174.2 of making my skills and my ability, to the extent that I'm able to make any contributions, available to all colleagues. And that's always been my attitude, whether in the time that I've been privileged to serve at the Supreme Court of Appeal or on the KwaZulu-Natal bench, and even prior to that, as a member of the bar in KZN for over 18 years, 8 of them as a senior counsel. I think I can only offer that openness, that ability to assist, as a contribution to what I think the fathers of the Constitution sought to achieve by Section 174.2. I am honored to have, certainly from my days at the bar, pupils, one who in fact gave a nomination letter supporting the present application, who were my pupils, subsequent colleagues, who have since taken silk, both of them, and who have even also acted as acting judges with me. So I try and make my contribution in that context.
Thank you. And lastly, and on a lighter note, you say at page 22 of your documentation, open quote, although there are a number of other former attorneys presently serving as judges of appeal on the bench of the Supreme Court of Appeal, to the best of my knowledge, I shall be the only one who has qualified in addition as a notary public and conveyancer, with the exception of one judge whom you have mentioned.
Yes.
Obviously, leaving other colleagues like myself out of the equation, because I practice as an attorney, notary public, and conveyancer for 24 years.
Judge Petse, my sincerest apologies. I made those inquiries with a member of the SCA who said to me that, no, there are no conveyancers and notary publics here. But, well, let me not refer to the particular member that I mentioned there, but I don't think she'll mind. Justice Molamela, who qualified as both. But I'm deeply sorry that I didn't give recognition to your additional qualifications. I certainly recall you.
Thank you.
From the days.
Thank you, Justice Kuhn. You are forgiven.
Thank you.
Okay.
Thank you, DCJ.
Thanks, President. Commissioner Notjes?
Thank you, DCJ. Good afternoon. Yes.
Good afternoon.
Thank you, Judge Kuhn. I've looked onto your cases. Have you ever been called upon to deal with a case that requires the application of the customary law, and you had to, in accordance with Section 211, sub 3, apply the customary law? You are obliged to do so.
Yes. No, I haven't, unfortunately so. I've read with much interest a little booklet that was prepared by our DCJ, Madondo, on traditional courts. I have followed the progress of the present bill with some interest, the exclusionary provision, and I'm waiting for it to go through the National Council of Provinces and for signature by the President. But that's on the traditional courts. But traditional or customary law as such, certainly in the High Court, I haven't had an opportunity to do that now.
I'm asking you that question simply because as a senior judge in the division, you are one of those judges who essentially in this area of the law, and especially in view of the Constitution, that demand for the application of customary law where it applies, gives that obligation.
Yes.
You had an opportunity to do so if you wanted to, as a senior judge.
I don't, as a general rule, deal with allocation or get to allocate cases. They get dealt with by our, at the present, acting judge president, or then a deputy judge president. So those haven't been allocated to me. I generally just deal with what comes before me. In recent times, I think the most significant one, to the extent that it involves an application of some customary law, has involved the wills and the succession to the late king. And that was dealt with by, it was taken control of and dealt with by the acting judge president.
Yeah. I'm asking you this question for two reasons. One, at the SCA, in my view, one of the demands for a person who's appointed there is that he must be an all-rounded judge. So if you do not have, you have admittedly an area such as customary law, you have no exposure. That's a concern to me. Mm-hmm. The second reasons for this question is that there is criticism. Recently listened to a debate in which Judge Hlophe and others were discussing the same, and even in the JSC this has often been coming up. There is a criticism that courts do not want to or are reluctant to apply the customary law as a system of the law. So those are the two reasons why I'm asking this question.
Yes, starting with the latter first, I would have no reluctance to invoke it and deal with it, and I would love an opportunity to get my teeth into something like that. But it hasn't been allocated to me, and that's all I can say. I would relish the opportunity if it could be allocated to me.
Yeah.
So I can deal with it.
Lastly, I see you attached the judgment, the judgment that concerns your rulings in the matter of State versus Jacob Zuma.
Yeah.
But the last one is the one that I want to ask about is your ruling regarding really adjournment of that matter,
yes,
which is attached. What is the significance of attaching that judgment? How does it assist us in dealing with your application, or what point do you want to establish by attaching that judgment, which purely related to your ruling regarding an adjournment of the matter?
Yes. Can I answer it like this? The questionnaire requires 3 judgments to be attached. I had Supreme Court of Appeal judgments, and then I thought, no, I must attach a more recent judgment and something that's topical. And one of the bigger judgments, or more significant judgments, perhaps in the interim, has been that relating to Thales and Mr. Zuma. And you are undoubtedly aware that a lot of pressure is brought to bear, certainly in the court of public opinion, not that I am governed by the court of public opinion at all, by delays that ensue and of appeals taking time. And I was really annexing this judgment to show how I have an appreciation for how the law has changed in regard to what principles govern appeals in a matter of this nature and the delays that ensue, so that there's a better understanding of it. The previous sort of regime prior to what was introduced, well, when I say previous regime with Western areas, S versus Western areas, and the judgment of Howie P, changed significantly with the provisions of the Superior Courts Act 10 of 2013 taking effect, and its definition of appeals. And the area is now quite a complex one. Appeals have become quite a hot potato being discussed at times. And I think that what I was trying to demonstrate to you as commissioners was this is not the adjournment wasn't just something that was a convenient thing to grant out of the air. It was a considered judgment in the light of numerous, not always all that clear principles, but which I've tried to set out in the judgment which I've annexed. And I'm hoping that by annexing it, I've demonstrated that ability and that skill to navigate also this area of law, which often might be seen as a neglected area. And it's an area that possibly, as I think I might have, I don't know whether I said it in the judgment, but in one of the judgments, that might require some judicial reform at some point, because it's quite a messy area where what is appeals in a civil context in terms of the Superior Courts Act also come to apply when one gets to stages where there's a consideration or a reconsideration application in a criminal matter, which falls under Section 17(2)(f) of the Superior Courts Act, and where the two then merge. So it's you've got to keep a cool head about things, and that's what I was trying to demonstrate, and I hope I have.
Well, thank you, Judge Kun. I would have loved to debate with you more, but unfortunately time is against me. Thank you, DCJ.
Thanks, Commissioner Nikis. Commissioner Pillay?
Thank you, DCJ. And perhaps, Judge Kun, I could just start following up on that line of questioning. You're aware of Article 4 of the Code of Conduct that entrenches the principle of judicial independence.
Yes.
And the notes attached to that article, which emphasizes that a judge acts fearlessly according to his or her conscience, and that you're only accountable to the law. You don't pay heed to political parties or pressure groups, etc.
No.
And in your experience, Judge Kun, do you find that most judges around you would adhere to Article 4?
Yes, I think they do. Yes, no, I certainly think they do. And I speaking for myself, I certainly adhere to it unreservedly.
Now, the reason I ask, Judge Kun, because I was interested when I read your application to note that there were two specific instances in your application where you raise your handling of a matter to almost want special points or special recognition for acting impartially. The one is the Clearly matter, where you mentioned the fact that this is a minister's wife you were dealing with, and the other is a matter involving the Cape Bar Council and this body. And I think your narrative mentions the fact that it's a demonstration of how independent you are because you acted fearlessly against you gave a judgment fearlessly against the interests of the JSE.
Yeah.
Now, both those instances raised a bit of a concern for me, because the two issues which you highlighted and you bring to our attention almost in a bid to get special recognition, or in colloquial terms, brownie points, are really what we expect from judges on a daily basis. I mean, it's a minimum kind of expectation that judges would discharge their obligation and their functions in that manner. So perhaps you just want to explain that.
Yes, no, it's certainly something that follows from Article 4. If the way the form was completed conveys that some special recognition was being sought, then it's created the wrong impression, and I apologize. It's not what was sought to be achieved. It is simply stating that I decided the matter according to my conscience, and yeah, there it is. It's what I required to do, and I did it.
Just to pick up on that, Judge Kuhn, when I read the transcript of your previous interview,
Yes.
And you'll see it at page 258 of the bundle. I'm not sure if your bundle is paginated the same way ours is, but there's the transcript of your interview right at the end, at paginated page 258.
Yes.
Where you touch on this issue and you say, I granted the application for leave to appeal without reservation to the SCA. All I sought to convey was some judges might, and I'm not saying will, when dealing with a sensitive case like this, possibly have an eye on the future. I have always wanted to be a judge. I was hoping to advance my career as a judge. It's again just tying on to this theme that you seem to indicate that you acted almost in a special manner or in an exceptional manner, unlike other judges, because you approached the matter impartially.
No, there couldn't be anything further from the truth with respect. As I said further on, it was purely at the level that if it was to be held against me, that I've conducted myself as properly and as I should, well then so be it. That's all I was saying. But I was never qualifying my duty.
And then if I could just finish off this line by taking you to the Zuma judgment, and I just wanted to again understand your reference to the Court of Public Opinion, and how did that feature in your decision, in your Zuma judgment?
It didn't, sorry, I interrupted you.
My question is complete, you may answer.
Thank you. It didn't enter my mind at all. All I was saying is I was asked about why, or what significance the judgment has, why it was annexed. And I annex it, I think, to demonstrate the issues and my reasoning behind the conclusion to which I came. Notwithstanding there being public pressures about why are there all these delays, etc.
Thank you, DCJ. I think I've got time constraints.
Just a quick follow-up on that one.
Commissioner Malema?
We've not been doing that since we started. So. No, Judge, I have a problem because in answering that question, you are the one who just brought the issue of public opinions, that not that I'm influenced by it, but the issue is there, and I was trying to demonstrate that I don't take that into consideration, as if you are expected to take that into consideration. What informs that? Because clearly you are trying to tell us somehow you get influenced by public opinion, because it doesn't arise. No one has raised that matter, including the two-sided cases. You are the one who just bring them to the fore to demonstrate that there is some influence which you are not supposed to get from anywhere. You ought to act independently, fearlessly, without any influence. But through the answering you gave now, clearly you are taking these things into considerations, because no one spoke about such things. You just brought them up on your own.
Yes. I don't take it into account at all. I give my judgment according to the dictates of my conscience. I raise it in the context of the question that was raised as to why I chose this particular judgment to annex as one of the judgments. And all I was seeking to do is to say it demonstrates the principles according to which I decided the matter according to the dictate of my conscience and to the best of my ability. There are other people, maybe outside there, would call them whatever one wants, court of public opinion, whatever, that might criticize some of the adjournments that I've granted. And all I was saying is, I annex this judgment because it demonstrates, hopefully as part of an educational function, to outsiders, what the issues were that I took into account.
I agree with you, Judge. That is the type of the answer we expect from a judge. And don't take it further to the public opinion, because you said, I'm raising this matter because I decided it on the basis of the best of my conscience, and I looked at the facts and I decided. Then you go further to say, despite the fact that there were public opinions and all of that, I still acted. So now you are inviting the public opinion, which we never invited here.
Yes. No, okay. As I say, I was simply trying to demonstrate why I was annexing this particular judgment.
Thank you, DCJ.
Commissioner Marumafai?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon to you.
I want to take you back for a moment, and in your explanation of what you believe the judgment of Mahlangu was about, and in explaining to us your approach in relation to the majority judgment that you gave.
Yes.
And I wanted to debate this with you, but I thought maybe other commissioners will deal with it. And of course, this I tie it with the BLA's comment in relation to their view on you and the constitutional part. And my comment or question is related there too. When I look at your majority judgment, you refer to section 12(1) of the Constitution. I mean, even regard to the facts, of course, but you don't appear to be discussing it. And you refer to it in paragraph 13 of your judgment. And then the minority judgment in paragraph 87 tries to contextualize why that section might be important in this case. And the Constitutional Court actually goes a distance in showing why it is important. And you took the line of causation. And of course, the Constitutional Court, the way I understood the judgment, it tied causation with unlawfulness, hence they went to vicarious liability. My question to you is, do you believe that, in light of the explanation that you gave us when you started, do you believe that the Constitutional Court judgment somehow it is wrong? And of course, I mean, you can think that the Constitutional Court judgment is wrong. The judgments that are coming from that court, they can be wrong. So don't be afraid to answer that part, if to the extent to which you feel that it is wrong. But in relation to the facts and the law, the way it has been applied, do you think that your approach was correct, and that of the Constitutional Court in particular was incorrect under the circumstances?
You know, it's a difficult issue to answer at the level of courts always differ, or often differ. I wouldn't have given the judgment if at the time that I wrote it, I didn't, and I wrote it after much discussion, certainly with some of the judges that concurred with me. I wouldn't have written it if I didn't believe it was correct at the time. Causation is often a difficult issue, as I think you know, and I thought there was an interruption, and it should be split in the way that I tried to explain it. But that's why we have a higher court, and the Constitutional Court has now said, well, effectively, drawing a distinction or treating it almost like a novus actus in between is not the way to approach it. It is the unlawfulness and what arises from it at the outset, the arrest, before the first appearance, before when bail could have been applied for, and for months and months and months that the matter could have stayed. Oh, sorry, that the the detainees remain in custody, it survives, it affords a remedy in law. That's the conclusion to which they've come, and I unreservedly accept that. That is so. That's how we learn.
No, thank you very much.
It's part of a learning curve.
No, I take your point. The last question that I have for you, I see that you practiced as a senior counsel for a number of years.
Yes, for 8 years.
Yes. And this question, I'm raising it against you, or I'm confronting you with it, not necessarily for you personally, but because, but based on what is happening generally in South Africa, and I'm hoping perhaps maybe there will be some change. My fundamental concern with the practice of law is we don't see many senior counsels taking on particularly female junior counsel, and in all the important matters that they are dealing with. We look at the Constitutional Court, you'll have three counsel. There will be white male, then perhaps maybe one black person. Majority it will be male. And in most instances, it's rare to see a female senior counsel. There are there, but it's rare to see a female senior counsel being the lead in these matters. In your practice as a senior counsel, have you roped in junior advocates, particularly black people? If you have, I'm not sure if you have that perhaps in the top of your head. And of course, as a judge as well, what role are you playing in ensuring that at least there is some encouragement for opening up the space for female advocates?
You know, our role as judges in promoting particular legal practitioners is obviously very limited. We don't necessarily, or we don't know until very shortly before a matter appears who might be appearing in the matter. The choice of counsel will be that of the litigants. More and more, and perhaps before I say that, my experience as at the bar, as an advocate, you must now please remember, goes back to prior to October 2006. It was a different ball game then, and I'm not suggesting it was the right ball game. I see things have changed. We don't get the opportunity really, although it has happened in the past, that you might find that there's a particular tricky point of law that needs to be argued, and there's a litigant in person. And you will not get the benefit of a full legal argument by just having the litigant in person doing the best he can in a very difficult situation. And then we often approach the secretary of the bar or the chairman of the bar to appoint a member of the bar on a pro amico basis to assist that litigant. That normally is a communication through the judge president or somebody more senior. It happens in very, very isolated situations, as I think you can probably appreciate. Those might be opportunities where in the future we should say, well, we request that a particular female advocate be appointed, or that a female advocate be appointed together with or a more junior advocate of whatever gender or racial group be appointed, because it affords them the opportunity to gain experience, often with a senior. But briefing patterns apart from that are really dependent on the instructing attorney. But I have, for example, an opposed motion this coming Friday in Pietermaritzburg, where I collected the heads of argument quickly on Friday, and there's a counsel signing the heads of argument, and then co-signed by, I've forgotten the name of the person or the two, but as he's appointed, quote, devil, unquote. You're familiar with the term deviling for another advocate. It's rendering assistance, doing research, and that kind of thing. So I'm quite looking forward next Friday to seeing, it's a senior counsel, and with him this devil that he has appointed. I assume it's on a non-numerative basis, but that's the kind of thing that I think can be encouraged.
No, thank you. I think I'm covered.
But as judges, I don't know that we've got too much control over it.
DCJ, quick follow-up, please.
All right.
I know the person who asked the question said he's covered, but that was not the question. That the answer was not to the question asked. The question was, did you brief, when you were still a senior counsel, female lawyers, advocates, other senior advocates or juniors? Did you brief black advocates, seniors and juniors at that time? And in trying to answer that, you said there was a different ball game at that time when we were still practicing. I want to understand that what was the different ball game in 2006 after 1994. So you may want to take us into confidence as to what are you talking about yes. A different ball game.
Yes.
We're not asking about judges choosing representatives. That one we know. But we want to know historically, when you were still practicing, what was your attitude on black advocates, juniors, and female advocates?
Yes. The question that moved on to what judges could do, and I was dealing with that perhaps because it arose last and it was fresher in my mind. The position in 2005, 2006, around there, we didn't generally, or I certainly didn't, and it wasn't at the bar, a general practice of involving or instructing other advocates to appear with you. I think, if I cast my mind back, we might only have had one or two, at most, female advocates at the bar where I practiced in 2006 or thereabouts. The question of deviling and getting the consent of the instructing attorney that instructs you to involve another person, a black advocate, who, for example, in your case that you've referred to, or in your example, wasn't generally followed at that time. My contribution in that regard consisted mainly, as I said earlier on, in having a number of black candidate, I beg your pardon, pupils, offering the lectures for them to pass for all the pupils to prepare for their bar examinations and to assist them in that regard, and also always, once they start practicing, to have an open door policy of inviting them to approach me and to spend time with them to answer any questions they might have or problems that they might be experiencing.
Have you finished with him, Commissioner Madam? Okay. Commissioner Steinberg?
Good afternoon, Judge.
Good afternoon.
Two questions for you. The first is we all agree that there's no place for public opinion in the writing of your judgments. But the question of the public perception of the judiciary is a legitimate one, and is in fact all over the Code of Conduct. It's necessary for public acceptance of the authority and legitimacy of the courts for a democracy to work. With that in mind, there is concern about the delays that take place in our courts, where respondents or defendants who have access to the resources can string out their cases for years and years, sometimes going on 2 decades, bringing endless interlocutories and then appealing them, and the primary matter gets held over. You are presiding over the SV Zuma matter, and until the last leg, you dealt remarkably expeditiously with the many interlocutories before you. It's now once again in abeyance. So I have a specific question and a general question. The specific question is there something that stops a judge in your position from going on with the primary matter while appeals wend their way through the courts? And the general question is, what do we do about the problem? What reform is needed to empower judges to hear cases timeously?
May I, with your permission, just divorce the question from the pending case of State versus Zuma, because there are developments and it's an ongoing case. And I feel a bit uncomfortable. Questions have been asked about it, and they were really dealing with events in the past. They were non-controversial, and I thought I could answer them. But just to avoid any impropriety, may I
Judge, go on.
Yes, may I deal with appeals generally? Public perception yes, public perception is certainly a very important aspect when one comes to respect for the law and for the public respecting what happens in courts. And I see public perception in that context as courts being required to have a very important educational role, in the sense that you must write a judgment and you must explain as simply as you can, hopefully, why certain results and consequences flow. And if they delays, they result because that is what the law requires, that a particular person, let's say in the context of a civil claim, has a right to appeal, and when he files his application for leave to appeal, then there is a delay. He or she, in a civil claim, might have not particularly good prospects, but one can't just simply deny that right to appeal because you, as a presiding judge, think they don't have particularly good prospects. You can say, well, I refuse leave to appeal, but if then thereafter they petition the Supreme Court of Appeal, which they are entitled to do as a procedural, as a systemic issue, then the delay that ensues until the Supreme Court of Appeal considers the petition is an inevitable delay. But you make a very valid point, and it gets back to the issue that I raised earlier on about possible law reform. Generally, forget about criminal matters, because it's a slightly more muddy field, as I tried to allude to earlier on. In civil matters, it's essentially governed in terms of Section 18.1 of the Superior Courts Act. Now, 18.1 says that as soon as a person who's dissatisfied with a judgment files an application for leave to appeal, that automatically suspends the judgment. There's a procedure in Section 18.3 for the other party to apply to court to have that judgment put into operation, notwithstanding the application for leave to appeal. But absent such an application in terms of Section 18.3, the consequence in law, which is the legal principle which I'm required to apply, is that as soon as there's an application for leave to appeal, that suspends the procedure. That essentially, 18.1 essentially accords with what the common law provides. I've often asked, or I ask myself, and I ask it in this context, on this platform, whether we haven't reached the point where when an application for leave to appeal is filed, 18.1 is amended to read, not that it automatically suspends the operation of the judgment, but that it doesn't suspend it, but that it may be suspended in the discretion of the judge. And the reason I say that is simply the following. You can have a big civil dispute that is prepared for months and months and months. Senior counsel, junior counsel, everybody preparing. You run your evidence. It takes 2-3 weeks in a court of law. At the end of the evidence, the judge takes 2 or 3 or 4 weeks or whatever. He researches the law, he or she researches the law. They write a comprehensive judgment, which is a very good piece of work. It seems to accord with the law. It is virtually appeal-proof. It is correct on the law. And what does the disgruntled party do? He can put in a single page where he writes, I appealed to the Supreme Court of Appeal or to a full court on the following grounds. The learned judge, paragraph 1, failed to apply his mind properly to the matter. He overemphasized the importance of the, let's say the plaintiff one, the plaintiff's evidence, and disregarded that of the defendant. And that suspends the entire judgment. Hasn't the time come that when we have an application for leave to appeal, it should be left to the presiding judge to say, yes, I do, as the one who wrote the judgment, I know I have reservations on certain points, therefore, pending the appeal, I am not going to let this judgment be carried into effect, but at the same time also, that if it is an appeal that has no prospects, as much as one cannot deny the party the right to appeal and to pursue it further, to petition and whatever to the Constitutional Court, but at least, mero moto, the judge can say, the operation of this judgment won't be suspended.
Thank you. My second question is merely, I want to give you an opportunity to respond to the BLA's adverse comment in this way. Are there any particular judgments that you have penned that you would point us to that demonstrate your ability to grapple with constitutional matters?
You know, the comment, sorry, I always get confused now. I always look at the first one. That's the one that's the one I must ignore.
The comment...
Yes, no, I have it, thank you. It didn't define or didn't identify any particular judgment. If it had, then I could have given you chapter and verse on what my thinking was. But in every case where there are constitutional rights involved, I obviously am required, and I do weigh them up against each other and give consideration to it. The fact that one comes to a particular conclusion, which a particular commentator might think is the wrong conclusion, doesn't necessarily mean that you didn't consider all those constitutional rights. I'll mention one. I did not bring it with me, but there's a judgment that went to the Constitutional Court, in fact, MEC for local government versus, it involved 2 municipalities. The one was the municipality of Nkandla. There were 2 municipalities, the other one's name escapes me now, but in both those, a municipal manager was appointed who didn't have the required qualifications to be appointed as a municipal manager. But because of certain internal strife, the person was appointed, and then the MEC subsequently took steps to have them removed in terms of the legislation on the basis of legality, a legality review, that they didn't have the required qualifications. Now, questions arose of the delay because the MEC had taken some time before initiating those proceedings. So here we have a number of constitutional rights involved. You have the municipal manager's right to employment, to follow his occupation. One has administrative rights involved. You have the principle of legality involved, all constitutional values that have to be weighed up. Following Gajima, we also know if you have a review, even if the delay is unreasonable, if it's excusable, you've got to look at all those considerations. I concluded that the delay, if I remember correctly, although a long delay was not unreasonable, that the principle of legality, that having regard to our municipalities, having regard to the state in which some of them are, that a consideration such as whether your municipal manager is properly qualified outweighs those other rights or values of the Constitution. But it's a value judgment. But I engaged in those things. I then concluded it should be removed, went to the Supreme Court of Appeal. I granted leave to Supreme Court of Appeal. 3-2 judgment. Ponnen was in the minority. I can't remember who wrote the majority judgment. 3 said no, shouldn't be removed. The delay was unreasonable, not excusable. Ponnen said no, legality prevailed. So it showed once again, he had as difficult a problem also with respect as I would have had. And then it went to the Constitutional Court, and the Constitutional Court said the delay was inexcusable, and that this person, or these two persons, although they don't have the formal requirements necessary to be a municipal manager, could remain in their positions. But I mention all that, the entertainment value or the value doesn't lie in the result. It lies in the fact that there's one case where all these competing values and rights were being weighed up. And there'd be many other, but from the top of my head, I didn't prepare on this, but what you've asked me,
You've answered the
yeah,
question.
they might not. The person who wrote the report, if he had that particular case in mind, might have thought that what the Constitutional Court eventually decided, or the majority decided in the SCA, was a preferable result to what I and the minority in the SCA concluded. But that's inherent in litigation. Doesn't mean you haven't engaged in assessing the competing values.
Now, I asked the question precisely because I'm concerned about criticisms that are made, which are very difficult to answer because they're non-specific.
Yes.
So I offered you the opportunity to answer it in a positive manner, to try and be fair, and you've done so. Thank you.
Thank you for the opportunity.
Any further questions for the candidate colleagues? Colleagues on the virtual platform?
I'm covered. Thank you, Deputy Chief Justice.
Thank you. Yes, is that Commissioner Barnard?
Yes, just confirming I'm also covered. Thank you.
Oh, thank you. Anything you want to bring to our attention before you go, Judge Kun?
No, nothing further, thank you. I don't think there's anything further. Thank you for your patience and for extending the interview to me.
You're right. Pleasure. All right. Thank you. Thanks to you too, and you're excused. You're
Thank you.
excused.
Thank you very much. That's fine.
Okay. Oh, okay. Oh, that's quite interesting. Are you settled, Judge Makaula?
I'm trying to,
All right. No, just relax. You're in good company.
it's not easy at all.
And
Thank you, TCJ.
First, before I start putting, leading the candidate, I should disclose that he and I have known each other since we were young students. We are good friends, but that does not affect anything that happens here. Right. You hold 3 degrees, Judge Makaula, a BUris and LLB from the then University of Transkei.
That's correct. That's correct.
And the masters from Georgetown University.
Correct decision. That's true.
Did you specialize in any particular field for your masters?
I specialized in international criminal law as well as labor law.
Right.
And I even did my internship on labor issues.
You started your legal career in 1984.
That's correct.
As a clerk. I take it that would have been at the magistrate's court?
Yes, that was at the magistrate's court, Mount Frey. I had a bursary which required us to work during holidays.
And you worked as an interpreter?
Yes, I worked as an interpreter. In fact, I worked almost all the offices in the magistrate's office.
And you rose through the ranks, you became a prosecutor and then a magistrate?
Yes, I rose through the ranks. I was a prosecutor since 1986. I think June moved to legal planning in the Department of Justice and then back to the magistrate's office as a magistrate.
But then you decided to leave public service and did articles of clerkship?
Yes, I was recruited by the late Justice Dugada, who offered to give me the salary I was earning, so I couldn't resist that. And then I went to do my articles with him at DZ Dugada and Company.
And then you practiced as an attorney for some time?
Yes, I started in 1993. I was in partnership with Svuile Sandelezilwa for 17 years before I was appointed.
You've been a judge of the High Court since 2010?
Yes, TCJ, I've been a judge from 2010. Okay. Having acted for 3 years prior that.
How long have you acted at the Supreme Court of Appeal?
I started on the 1st of December, 1st of December or January, I can't recall, but I've been acting since January till on Friday, the 30th of September.
So that was your 3rd term then?
That was my 3rd term, yes.
All right. How many judgments did you produce during your acting stint at the Supreme Court of Appeal?
During the 1st term, I produced 1. Then the 2nd term, I produced 2. Then this term, I produced 3. The 3rd term.
So you have 6?
I have 6, yes. I have 6 now.
Were you able to keep up with the rigors of the court? How did you fare?
I fared very well. I fared very well. I was able to keep up.
Were you able to deliver your judgments in time within the 3-month period stipulated in the norms and standards?
I was, except for Sitau, which was quite an involved matter. Otherwise, the rest have been delivered within term.
I allocated you the judgment in Sitau.
Yes, TCJ.
And just repeat again why you say you delayed the judgment there?
It was delayed because it was quite an involved judgment. It had a lot of volumes which I had to scroll through, and even I had to go through about, I think the core bundles themselves were about 7 or 8.
I think it's the GCB, well, both the GCB and the BLA are not entirely happy with your candidature. The BLA doubts that you are ready to join the SA at this stage. And then the GCB makes reference to a concern that is not new where you are concerned. It's something that has been raised with you in a previous interview here.
Yes.
That you have a tendency to delay delivering judgments. What do you, or do you want to say something on that?
Yes, I just want to...
They've specified a period that you have reserved judgments for a period ranging from 5 to 7 months.
Yes, Mr. Jane. It's not in my nature to reserve judgments. It depends entirely on the circumstances under which I find myself in. Like, for instance, I've checked on the judgments which apparently the GCB is referring to, and I was able to pull out the roll for that term, which I have in front of me. May I just go through it,
Yes,
DCJ? Yes. During the period of February, which is the concern, I picked up 4 judgments which they were talking about. During that term, it starts on the 10th of February. I was doing duty. The following week, I was doing appeals in Grahamstown. And the third week from there, the 9th of March 2020, I was doing duty as well. And I was able to pick up the roll as well as my book. I pick up no less than 4 judgments during that period. That is the first week on the 10th. And then again, I pick up about 2 judgments on the 17th, the week of the 17th of February. And because these matters which they refer to are quite involved, I took time to deliver those judgments. It was not because they were the only matters which I had, but it is because that there were other matters which I had to attend to as well. And it's not easily done. The JP will confirm that. It's not easily done in the Eastern Cape that you are allocated duty this week, and then the following week you are allocated appeals, and then the third week thereafter you are also allocated appeals. We made a resolution that in the event that a judge has to do duty or appeals, it must be twice in a term, not in succession. Because once you are it's done in succession, you are likely to be swamped. You are going to pick up judgments which are going to swamp you. And even the following term, which deals with the 2020, I think it's 2021. This is for 2020, those judgments which were affected in 2020. Then the other judgments which were affected were, in fact, I've got the year, that is in March 2021. A similar thing occurred. I was on duty in 2 successive weeks.
All right.
And in that event, DCJ, it's not easy at all. I don't take away what they are saying, but it's not easy when you pick up more than 3 or 4 judgments to deliver all of them in time.
All right, let's just go back to your stint at the SCA. You listed 2 reserve judgments as outstanding when you submitted your application. Well, I know for a fact that Stau has been delivered. What about the other one, Diljan?
It has been delivered and it was reported as well. I think Diljan was reported. No, it's Baloyi which was reported.
Sorry?
It's Baloyi that was reported as a reported judgment. Diljan was delivered on time as well.
It was delivered?
Yes. Okay. It was delivered in term, during term.
Mm-hmm.
Yes.
Okay. I just want to go back to your judgment writing ability. And I just want you to respond to my question as honestly as you can. Do you believe that you are at a stage where you can write a good judgment without the need to be handheld by the rest of the judges panel around you?
I believe
Have
so.
you reached that stage where you can write a good judgment on your own?
Yes, I believe I can do that.
You have?
Yes.
But that was not my experience in the 6-hour matter. It was a struggle to get a judgment out in that matter.
No.
As I recall, even when senior colleagues had made their inputs up to the stage of conference, when I had already left the court, because I was not there during the conference, and a letter was circulated by one of the senior judges in the panel, pointing out that after the conference where all the final inputs will be made, and the scribe, which was you in the case, has been given all those well, not suggestions, all those edits to implement. Still, the judgment that came out was not correct. It had to be corrected substantially. And that gave me the impression now that you had struggled just to proofread your own judgment. Was that not the case?
It must have been the case, but I think I spoke to Judge Dambuza because I had a problem with my secretary. She sent a wrong judgment. And Judge Dambuza is away.
I'm sorry, just repeat that.
What I'm saying is the secretary sent a wrong judgment. And if you look at it, DCJ, even that judgment that was sent, it did not highlight all the comments which were necessary in terms of colors. Like you normally, as the stripe would be yellow, the others red, but she just circulated a wrong judgment.
But you do understand that at the end of the day, the judgment is yours, it's not the secretary's.
Exactly.
So it is your duty to ensure that what is circulated to the rest of the colleagues is the right thing.
Exactly, it is my duty. And if, I'm not computer literate, unfortunately. If she says she sent the right judgment, and then it is discovered that it's a wrong judgment, to an extent what we did with Judge Dambuza, or Justice Dambuza, is that we changed the secretary and used her own secretary. Just because of the same reason I'm talking about, because she kept on making mistakes after mistakes. And then Judge Dambuza suggested that we should use Sbongile, that is her secretary.
Well,
And in fact, eventually it is her, if you look at it, who eventually ran with the judgment until it was delivered. Because the secretary I was allocated was really battling.
One last question from me on this aspect. I'm not talking about you being computer literate or not. I'm just talking about making sure that your secretary actually sends out the right document, and you don't need to be computer literate to be able to tell that.
In that,
especially when you know that they are struggling, they are lacking here and there. When it comes to a final draft of a judgment.
In that instance, TCJ, once you push that button, because I was with Judge Dambuza even at the time, once you push that button, it's gone. And that is why I pleaded with Justice Dambuza. And in fact, she insisted that let's rather not use her and use her secretary. She was equally frustrated as I was.
All right. Lastly, you have also listed 4 parted matters. Those would be in your division in the Eastern Cape.
Yes.
How far along are they?
There are 3 of them are civil matters are going to be argued. This next week, I think it's next week in October. Second week of October, I think that it will be next week. The other one is a criminal matter. It's coming, I think, on the 28th of October. It's for argument, as well as them having filed an application that the prosecutor must recuse himself.
So you do attend to these matters during recesses?
Yes, I'm going to attend to them even starting next week, Monday.
All right. Thank you, Judge Makaula. Colleagues, do you have questions for the candidate? Commissioner Nyambi. President Betsy, Commissioner Steinberg. All right. Commissioner Nyambi, go ahead.
Thanks, DCJ. Afternoon, Judge Makaul.
Afternoon, Commissioner Nyambi.
It's only one question. It's a follow-up to the one that has been raised by the DCJ about that computer literate judgment.
Yes.
As you are not going to be privileged to be part of the closed deliberations when
Yes.
dealing with this issue. And DCJ was part of the people that dealt with that case.
That
dealt with the case. As somebody who was not part of it, I'm more confused the more you're doing the explanation. Maybe if you can clarify why she is having that wrong information, but she was part of the very same case.
May I, with respect, ask which wrong information?
The wrong judgment that was submitted. We are saying it's the wrong judgment. It's saying, no, it was pen and pitted. There were some challenges in terms of that judgment.
What happened is this, Commissioner Nyambi. The secretary I was allocated attended to the corrections. The corrections were there, the judgment was there. And what happens in the SA is that if you're dealing with one judgment, it gets circulated on numerous occasions. Not once. You can find that you circulate it 3-4 times a week. So what happened in this instance is that the judgment was, I received comments from colleagues. And then we adopted the comments. And then instead of her accepting the comments, she sent the judgment raw as it is, with the comments still in those colors without them having been accepted. Because once you accept them, then you won't see the colors or the comments made by your colleagues. I don't know whether I made sense or
No,
not.
are you not the one that's supposed to make sure that what is sent by the secretary, it's what we have finally approved that she must send?
Yes, I am.
So where is the confusion still, if that's the case?
The confusion is that she sent a wrong judgment instead of sending a correct judgment. Because once you email them, you don't send a hard copy.
Let me put my last one. Probably as somebody acting in the SCA, what might be the challenges that are in the SCA with your experience?
The only challenge which I had is the question of the secretary. The only challenge which I had, and Judge Dambuza can attest to that. That's the only challenge which I had when it came there, when I came to the SCA. Other than that, the rest, it is okay. I worked very well at the SCA, collegiality is there. Other than that, I had a challenge with the secretary.
Why was it not properly explained to all the other colleagues that were part of the very same case so that they are on the same page? Because we are picking somebody that is not part of us now, but we've got a DCJ that was part of that process and has got a different understanding so that there is no confusion.
I may have made a mistake because then I should have maybe circulated something to the panel. I may have made a mistake. It's an oversight on my part, surely. I should have explained to them. The only thing which we did is just we shifted and then we used Judge Dambuza's secretary because I was not making headway. I accept, you correct, I accept that I might have made a mistake in that regard.
Thanks, Judge Makaula. Thank you, TCJ.
Sorry, before I move
Follow
on, I just to be fair to you, Judge Makaula, because I will be talking about this at deliberations, and I don't want to mention facts there that I did not put to you here. I omitted to mention just one important thing, that the reason that I could not attend the conference of the final draft was because I had to leave for the Constitutional Court. The matter had been set down for conference, and you had gone home, and on the night preceding the day of the conference, I got a call from my secretary telling me that your secretary had called her to tell me that you could not make it to conference that Monday afternoon. She called me on a Sunday because you had gone home and you just would not be available. And I had actually been stunned by that because it was an old judgment. It had taken time just for the first draft to come out. And there had been, all sorts of dilly-dallying. And now something totally unprecedented for a scribe of a matter when there is a conference to go home and not come back on a work day because conference was set down for Monday afternoon at 4 p.m. Can you just explain about that? I know that you have an explanation, but I'd like you to make it here.
I received a call from from my secretary on Sunday that there's a conference on Monday at 4. By then I was home and travel arrangements had been made. And my flight was arriving in Bloemfontein at 6:15 that Monday. I made a mistake and I admitted that mistake to both yourself. I'm sorry to say that
Yeah, that's fine.
DJP, yes, no, DCJ as well as AP. That I made a mistake. I should have called you on Sunday. Immediately when I got this information, I should have called you. I realized my mistake early on Monday morning, and I tried to call you. And having tried to call you, I even sent an SMS to you, apologizing. It was an error on my part. I accept it even today. I made a mistake, and I regret making that mistake.
Had you asked for permission to be away from the court on the Monday, which was a work day?
Not at all. I apologized for that, and I still apologize for that.
Last question, could you not have driven from your home back to Bloemfontein?
I could.
In the early hours of the Monday so that you could be there at 4 p.m.?
I could.
Thank you, Judge Makaula. Commissioner Malem?
I'm covered.
Minister?
Thank you, Justice DCJ, and afternoon, Judge Kaula.
Judge, good afternoon, Minister.
Yes, I'm also a bit confused on this issue of blaming the secretary. I want to understand, because my understanding is that even for a director of a firm, whatever that the secretary does, that person must take responsibility. And the person of your caliber as a judge, is it not a fact that if the secretary has said that it's you who must take responsibility for whatever that she has sent, whether it's a mistake or not?
I accept that, Minister, wholeheartedly. I accept that I am responsible. I was merely explaining what happened. I really honestly accept it, and I apologized for it.
Yeah,
I can't run away from the fact that I am the responsible person. I am the person who has to take the fall.
Okay, no, I think now I'm clear now. The second one is on this issue of that you have just declared of being computer illiterate. Are you planning to take some courses, or is there anything that you're doing to improve this situation? Maybe you could explain today.
Yes, I'm really doing it now. I really am trying to edit the judgment and do all those things. I am taking steps to learn that.
Okay. No, thank you, DCJ.
President Betsy.
Thank you, DCJ. Good afternoon, Judge Makaula.
Good afternoon, AP.
I'm looking at the feedback from the GCB concerning your reported judgments.
Yes, it is AP.
You have been a judge for 12 years.
Yes, AP.
And they've listed only 6 judgments that you wrote which found their way to Zuta's law reports and Butterworth's law reports?
Yes, AP.
Is that the sum total of your judgments that were reported over a period of 12 years?
No, it is not AP. It's only those which I referred to my in my questionnaire.
But
there are more than that. The reported judgments are more than that. That I have. I'm trying to find a repository which I was given by the researchers regarding those judgments. In fact, there are more than that, with AP.
Because the GCB says we have considered the candidates' reported judgments.
Yes.
And they list only 6 judgments.
I thought those which they listed are those which I touched.
But you were given that document from the GCB?
Yes, I was.
And you have had it for quite some time, knowing that you'd be sitting there today?
Yes.
Let's deal with this Sipao judgment, because it appears that it is an albatross around your neck.
Yes, it is.
I'm hearing for the first time that you had endless difficulties with your secretary at the SCA.
Yes, I didn't report it to you.
You are the scribe. Many drafts float around. Is it not your responsibility as the scribe, once your judgment has been to conference and further edits take place there, to ensure that the judgment which you circulate as the final version, pre-delivery, is the one which receive the attention of every member of the bench at conference?
It is AP.
Did you then tell your secretary that this is the final version of my judgment, and this is the judgment that I now want you to circulate and send to the other members of the bench for them to have a preview of the judgment, which will be delivered in a day or 2 days or 3 days' time?
Yes, I did, AP. I told her, and then instead she sent a wrong one.
Despite the fact that you had identified to her which judgment to send?
Yes, AP.
Then a conference note is issued on a Friday, convening a conference in the afternoon of the following Monday.
Yes.
And it is now common cause that you did not attend that.
Yes.
And the reason is that you had gone home for the weekend.
Yes, AP.
And that you had problems with flights.
Yes, AP.
But you knew even before you left Bloemfontein that you wouldn't be able to get to Bloemfontein on Monday, and that you would be away from court on Monday.
Yes, AP.
And you didn't find it necessary to make proper arrangements with the acting head of the court.
That was my mistake, AP. I made a mistake.
Is that not a manifestation of disrespect to the institution?
I wouldn't say so, AP, that I would go out of my way. I haven't done it in 13 years I've been a judge. I haven't shown any disrespect. And even when I came to your chambers to explain, I was hurting. Because it was a clear oversight on my part. And I was hurting to an extent that, I may mention this, to an extent that you even said that I should not punish myself that much. I was hurting because I don't want to appear in any sphere, and I haven't shown any disrespect to any elderly person for that matter, let alone to those who are above me at work.
And before you left for home, you had an occasion to accompany one colleague who had informed you that she wanted to come to me and remind me of the arrangements that she had made with me.
Yes.
That she would be going home for the weekend.
Yes, AP Tina, I did.
And yet it didn't occur to you that you didn't get a flight on a Sunday to be able to be at work on Monday.
If I remember well, the itinerary had not come out by then because I decided late to go home on a Thursday, but I don't deny that. I don't deny it at all.
When you were being asked questions by the chair of the commission, you told the commission that you can write judgments on your own and you are satisfied that you've got what it takes to be a judge of the SCA. Did I hear you correctly saying that?
Yes, I'm of the same view that I can write judgments on my own.
Notwithstanding the many difficulties that were raised with you by the other members of the bench with whom you sat in this matter.
Come again, AP?
Despite the fact that there were concerns raised by the other members of the bench in this matter about the quality of the judgment that you have produced in that matter.
No, I haven't heard anything from the panel. Honestly, I haven't. I've not heard any of the panelists. Because if I remember well, it was it was the DCJ, it was Judge Dambuza, it was myself, it was Trevor, Judge Govan, and Makhoka. They never raised any issues with me.
And all of them were happy with your first draft that you had circulated?
It had typographical errors, which they
No, on matters of substance.
No. The only person who raised issues of substance is Judge Dambuza. In fact, she inserted 2 paragraphs. The rest, it was cosmetic stuff. Then she only added 2 paragraphs.
So do I understand the position to be that in relation to all the judgments that you have written at the SCA, comments that you have received or you received from the other members were cosmetic changes only?
As far as I can recall, that is the position. Not unless maybe AP can refer me to a judgment. But in this matter, I'm certain. I am positive about the Slough matter.
There's a draft that you circulated last week.
In respect of which matter, DP?
Can you remember the name of the matter in which you circulated a judgment
Circulated?
that I had assigned to you to write?
Yes, the one you assigned to me to write?
Yes.
It's Placha Helmet, I think. Let me check. Yes, the Placha Helmet judgment. That's the Placha Helmet judgment, Mellet judgment. Then in respect of that one, I've only received from Clive.
You received comments from
from
one of
Judge
the
Plaskett.
members of the bench.
Yes, from Judge Plaskett. Then I received them, I think, on Friday morning.
Would you say that the suggestions that he gave you are merely cosmetics or are matters of substance?
I wouldn't say they're cosmetic, because what he did is, instead of quoting sections, he paraphrased those sections. That's how I viewed his comments. And that's what he said to me, because he came to my chambers. And he explained that, Mandela, what I did, instead of you referring to the text or to the contract itself, let's paraphrase it. And then I said, okay, I'll wait for other people to come up with their suggestions.
Thank you, Judge Makaula. That's where I'll leave it.
Thank you very much.
Thank you, DCJ.
Judge Makaula, it pains me to do this. I'd hoped that we would not go this far. But I have to place this on record. My conscience won't rest. Still about this judgment. The colleague, because I was the presider in the matter, it was my responsibility to ensure that the judgment is produced. So I kept checking with you as well when the draft would be produced, because I was worried that I'm leaving the SCA, I'm going to another court, and I told you that I don't want to leave leftovers. I want my desk to be clear when I leave Bloemfontein. Yet the judgment was delayed. Now, you told me that you had asked for the help of one of the senior judges in the panel, which was fine. I had no problem with that. And when I did speak to that colleague, they told me how they had struggled with the first draft you produced, and that the main concern was not about the substantive issues you had got wrong, but that you could not even get the facts right. But then it was a heavily fact-laden matter. I understand that. It was a big matter. But there was that concern that at least insofar as just setting out the factual background, you should have got that right, that much. And that was the concern of this colleague. And I understood throughout that, but what bothers me now is this, I don't want to get, it's more like acting on hearsay now, but I had no reason to disbelieve a colleague who was being helpful when they told me what they told me. And I just want to place that on record so that it's out there. You may respond or not. You've already put your version that it was just typos that were affected to the draft. And I may just add, lastly, I promise I won't say anything more about Stow now, that even when, after all the rehabilitation that the other colleague had said they'd done to the judgment, when it came to me, when it finally came out, I also made substantive suggestions to your judgment. Speak about what I myself did. And you know that.
Substantive.
Yes. Yes. I did, and I have proof. Maybe maybe our definition of substantive and cosmetic are different, but I know that I made, it was a decent draft, but I still made substantive suggestions to that draft. I'm going to leave it there. You may respond if
You know,
you wish.
it pains me. I'm pained. It really pains me.
So am I.
For someone to say that I could hardly produce the facts of an ordinary history which I've got.
That's the power coming back.
I still have. Sorry. I don't know. Yes, I still have the draft papers, which are handwritten now in manuscript. I still have them even now. I haven't destroyed those manuscripts. So it really hurts me for someone to say that I could hardly deal with the facts. And if you remember well, DCJ, I kept you posted. I sent you SMSs telling you the stage at which the judgment is.
All right. Thank you, Judge Makolo. We'll leave it at. Commissioner Steinberg, had you raised your hand at some stage?
I'm covered, thank you.
All right. Commissioner Matolo Lepu, then you.
Thank you, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Lepu.
Mine is just that I know that you explained the issue of the secretary, but do you think, because I don't want to remain with not understanding whether your secretary maybe needs training or there's something, because because there was something wrong with, because if the secretary sent a wrong judgment, she must have gotten it from you. I'm not sure. I still need that explanation.
She's more than 10 years, as I understand, in that court. She's more than 10 years. And Judge Tambuza, I cannot lie, Judge Tambuza is aware. The only problem I didn't do is to tell Judge Bates. Justice Bates or AP Bates, I'm sorry to say that. But Judge Tambuza know about the problem which I had with her. And to be honest, and if we speak honestly, that is exactly the reason why I changed and used Spongiseni, who is the secretary to Judge Tambuza. It's because of the endless problems which I encountered from the secretary. And even the secretary of Judge Tambuza, she knows exactly. Because each time she sends a draft to her, then it comes back wrong. It's honesty. I can't be lying about this.
Just to follow up, Deputy Chief Justice, I'm trying to assist that maybe the secretary needs upskilling, or we can't leave him or her if she goes to an extent of making your life difficult. Should we not, because at least the head of the court is saying maybe she needs assistance.
And even in my absence, they can go to Judge Tambuza. She will be explaining exactly as I say.
Thank you, Deputy Chief Justice.
Thank you, Commissioner Dolotlepo. Commissioner Lucas?
Thank you very much, DCJ. Good afternoon.
Good
evening,
Commissioner.
Judge Makola.
Good evening, Judge.
I should say I was extremely concerned when the issue was about the secretary. And I became more concerned when the head of the court was never informed about your challenges. Now, the first question that I want to ask you, as a very senior practitioner, as a judge or as an advocate or whatever you say, a jurist, you are experiencing a problem. How do you solve it What is the procedure at that court for resolving such an issue? That is my first question. Secondly, I get more confused because when you first started to say that there is a challenge with the administrative staff, you said that she took the report and you gave her all the amendments and they was never introduced into the document. Now at the end you say only 2 paragraphs.
Yes.
So I maybe it's English, I don't know. But also I'm taking into account of what the DCJ was saying, that some of them also made some amendments. But when you were speaking, you said all the amendments. So for us, it seemed as if there was quite substantial amendments to the issue or to the report. Now, and then in the middle, you say only 2 paragraphs by 1 person. And it's not, I mean, I don't want to seem as someone that are taking sides, but you are confusing me because I am not a legal person, but I'm getting confused because what is the procedure? And if there is no one else that amended, or if someone have amended and really you feel it is true, I don't think it will die if you say it is even yours that was not affected. But if someone putting it as a fact to you, I think there is a way to resolve the issue. But you are taking me up and down, and I should say many of us that are sitting here have been heading officers before. And we know if your secretary works on a document, the last step before it goes out of your office is to make sure that what is going out of your office, you can identify with it. So it is, in actual fact, I'm very disappointed that the secretary is being now put in front of us in such a high-level panel where the whole country is watching you. You are actually shifting responsibility. That is my view, and you can dispute it, but you are shifting responsibility. And also, you have, in actual fact, you are aggravating the situation because in the first instance, I was like so perturbed with this secretary that can take a whole court report and not affect the amendments before it was sent out. Now you are saying it's just 2 paragraphs. Now it comes back to the fact that you are now saying others didn't make amendments. What is the true story? Please, Justice Magola, assist us.
Yes, the true story is this. The secretary sent a wrong judgment. I should have seen to it that she sends a correct judgment. I am not shifting the blame to her. I am responsible for that judgment. I am responsible for the fault she has done. I am not running away from that. Regarding the judgment, I was only responding to the DCJ when she was saying that substantial changes were made on that judgment. The judge who is Judge Dambuza, when I sent the judgment to her, added 2 paragraphs and some type of attentions which I had to attend to. I don't know whether I answer your question.
I mean, what can I say? Thank you, DCJ.
Commissioner Nukes?
Good evening, Justice Makaula.
Good evening.
3 things that I just want to focus on. 1, in respect of the comments that have been made against you, including those of PLA and GCP, all those bodies, they support the nomination. I've not seen a person or an organization that say you are not you are not fit for the SCA. Like the question from there, would you regard yourself that would you say you are an all-rounded person who would qualify to be judge of the SCA?
I would suggest that it's a subjective thing, and then subjectively speaking, I am. But viewed objectively by other people, they may come up with something different. But even the comments, the judgments themselves, the comments of the GCP, because the more detailed report is that of the GCP. It is more detailed. It comments on the judgments which I've attached. It comments on the quality of the judgments. It comments on any other aspect of the judgment, and even the other bodies.
Yeah.
They comment on the linguistics, on the language, on the manner in which those judgments are written.
Yeah.
But
and this
hence I was taken aback when it was said I could not even summarize the facts.
I'm looking onto the BLA. If you notice, the BLA had two comments. The one is from the office of their president,
yes,
and the one is from the office of their secretary.
Yes.
I'm not too sure whether these two, in the respect of you, I haven't checked properly. Do they speak to one and the same thing about you? Because it seems as if the president gives a different comment whilst the secretary gives a different comment.
No, they don't. The secretary gives out. I think, as I understand, the comment of the secretary is that this was a matter which involved prescription. Then I should have I should have seized the opportunity of declaring the section unconstitutional, and then I am not qualified.
Lastly, TCJ, I'm sorry, the last question. Look, I agree with the DCJ and the president of the SA in respect of questions relating to attending conference,
yes,
and other matters.
Yes.
But where my difficulty is in respect of comments into your judgment. In the SCA, you sit 5 judges. These comments, I'm not too sure what is their nature. Do they relate to the language used, the question of punctuations in the judgment? Bearing in mind that people do write assignment, 5 of them in one class, taking from the same book, but they will get different marks. I'm not too sure. I mean, what my question is, mainly is, in respect of the outcome of that judgment, that you did one of those judges come differently, or somebody even decided to write a dissenting to your reasoning on those judgments?
What pains me the most is this. If a judge, like we are 5, has made substantial changes, the judgment would not have come out in my name only. That's how I understand the procedure. It would never have come out on my name only, because the contribution he would have made would be substantial. And therefore we would, like for instance, we were sitting in a matter with Judge Bonan as well as Judge Patswana. Judge Bonan came back with substantial changes to the judgment. And when we were conferencing, he said, because I've made these judgments, these comments, I think we should, both of us, be the authors of this judgment. Rather than being me or be you, then both of us should be. So I would have expected that if that be the case in the Stau matter, then surely I would not have come out as the only scribe or as the only author of that judgment. And I'm sorry if I may comment if DCJ allows me. Regarding the matter which AP is asking me about today, that there was a comment or a judgment which was referred. In that matter, it's just that, I just want to explain this. Judge Plaskett came to me with his own suggestions. We are a panel of 5. He came back with his suggestions. I haven't received 4. And I did not accept those changes which Judge Plaskett came up with. I did not. I said, okay, Clive, put it on my desk, then I'll wait for the other comments. Thank you very much, DCJ.
All right. Any further questions for the candidate colleagues? Prof?
Thank you very much, Deputy Chief Justice. Good evening,
Good
Judge.
evening, sir.
I think let's talk law now, and just take a break from the issues of the court itself. There is a judgment. Let me just make sure. Yes, there is a judgment that you penned, AR versus HR. It is a judgment. It's an insolvency law matter, where
AR versus
HR.
I don't have it.
You don't oh,
I don't
then
have
it will
it,
be a
I'm
little bit
sorry.
unfair for me to
I
to
don't
ask
have
you
it.
on it.
I've got the others. I'm honest with you.
Yeah,
Was it penned by me? If you may recall
it appears so.
if
Makau.
you have the facts, most probably I would be in a position to recall.
This is this was an application by an ex-wife for insolvency, for compulsory insolvency, because there was outstanding area maintenance.
Yeah, no, it's not.
You don't recall? Oh, okay. No, that's fine. I will leave it there.
No. Because the only matter which deals with spouses is the Macmillan matter, which I dealt with. Not this one.
No, it's fine. Perhaps
Yes,
maybe
thank
it's
you.
a different judge with the same name.
Thank
I'm not
you.
really sure. Yes.
Have you finished? Oh, thank you. Colleagues on the virtual platform, do you have questions for Judge Makaula?
I have no questions. Thank you, Deputy Chair.
And you too, Commissioner Bernard, is he still there?
Yeah, I'm still here. No questions, Elizabeth.
Okay. Well, we have reached the end of your interview, Judge
Thank you very
Makaula.
much,
Thank you.
DCJ.
You're excused.
Thank you. I think it's right, yeah. Thanks. Thanks.
Are you ready, Judge Mayor?
Thank you, Deputy Chief Justice. Yes, I'm ready.
Good evening. Are you well?
I'm well, thank you.
Good. You have been interviewed by the JSC for a vacancy in the Supreme Court of Appeal previously, not so?
I beg your pardon.
The JSC has previously interviewed you
Yes.
for a
I've-
position in the SCA.
Yes, I've been interviewed. I think this is my 4th time.
Yeah, and on each of those occasions, you did very well.
Thank you, Deputy Chief
Yes.
Justice.
Look, your last interview is the one that was conducted in 2019, am I right?
Yeah, that was the last one.
Okay, and we have the record right here.
Yes.
Your record speaks for itself. You're a seasoned judge, you've produced many judgments, you've acted many times at the SCA, and I think we know what the issue is.
Yes.
You just competed at a time when the demographics just didn't favor you, even the color of your skin.
And I understood it always,
Yes.
Deputy Chief Justice.
Yeah. So, in addition to what you've told the JSC previously, what do you have that's new now? Why should the JSC recommend you for appointment?
Deputy Chief Justice, in brief, everything is in the documents, also the comments received by all the different legal bodies. But I've been a judge of the High Court. Well, I've been an advocate for 21 years. I was a senior counsel for 3 years. I am a judge of the High Court for 15 years. In fact, on the 15th of June, my 15-year gratuity paid out. And I've been in the SCA altogether 2.5 years. I'm considered to be an experienced judge. Apart from Acting President Petse and Justice Ponnen, all the other judges in the SCA were appointed ever since I started to act in the SCA since 2013. And amongst us, acting judges in the SCA, there is a special bond. And I've also seen now over the last 3 terms that I've acted in the SCA, that indeed is a close bond. I've written many judgments. I am very experienced. I'm meticulous in the judgments I write. I always write also for the litigants to understand my judgments. In a nutshell, yes, I do believe that I have contributed already in the SCA and that I will contribute in future. Many of the lesser experienced judges seek my advice all the time, and I love to give it. And also, you've changed the SCA tremendously. The last 3 terms I acted was the highlight of my career. The atmosphere is completely different. You are aware of the fact that me and one of our colleagues in the SCA, female colleagues, started a social group where we go out for a quick supper on a Wednesday evening, and at 1 p.m. on a Sunday, we go for lunch, and we are always joined by a number of other colleagues. So, not only professionally, but also socially, do we build onto what you have created at the SCA.
I want to delve deeper into the question. I'm sure the President Petse will have a few questions to put to you on the issue of the constitutional imperative of race and gender. I will open your questioning to the rest of the
Yes.
commissioners. Anyone have questions for the candidate colleagues? Okay, AP Betzer?
Thank you, Deputy Chief Justice. Good evening, Judge Mayor.
Good evening, Acting President Betsy.
Well, in your brief outline, you have, dealt with the matters that I had noted. I would ask you about your length of service on the bench, and that from the April 2019 interview, I've had the benefit of reading the transcript. Unless I missed out something, I couldn't see any, there's nothing adverse there, unless you were to draw my attention to whatever I might have missed in that regard.
I don't need to. Thank you.
And the fact that you are appearing before this commission for the 4th time now.
Yes.
But I just have one question which I want to pose to you, just to give you an opportunity. Same question which I posed to the, to the other candidates. And given the constitutional imperative as provided for in Section 174(2), what factors would you like the Commission to take into account during deliberations, which you think would tip the scales in your favor, considering that this time round we have got 3 white male candidates and 2 white female candidates?
Yes. Acting President Betsy, without repeating myself, I've indicated the experience which I have. I've always been involved in transformation initiatives. I am meticulous in my work. I write judgments with clarity. As an acting judge many years ago, one of my judgments was overturned by the ECA. As a permanent judge for 15 years, one was overturned, and it elicited quite a bit of academic response. And after I lodged my application for appointment to the Supreme Court of Appeal in June, another judgment by the Supreme Court of Appeal came out, where a full court, in which judgment I concurred, judgment was also overturned. So I think that indicates the ability I have to review the judgments of other judges, and yes, of course, I am a white male, and there are currently, I think, 4 white males in the ECA, but I am aware of the fact that Judge Plaskett is retiring at the end of the year. So that in a nutshell is, and I'm very well known. I've got a very good relationship with all my colleagues in the ECA. So that may well tip the scale.
Thank you. On a lighter note, why have I been excluded from your social club?
But if I may, Acting President, remind you of personally inviting you, but you have other obligations on Sunday afternoons.
Thank you, Judge Mayor. Thank you, DCJ.
Thank you, Acting President.
Any further questions for the candidates? Prof?
Thank you very much, Deputy Chief Justice. Good evening, Judge. I'm here.
Oh, thank you.
I just want to understand your general experience at the Supreme Court of Appeal in between panels. Does it normally occur to you that there are judges or acting judges generally in panels who struggle to write judgments?
Yes.
And how generally does, or do those who are able to write judgments deal with that?
Well, what I always do when I see that there's a judgment that can be, let me put it this way, more perfect than it was written, then I always discuss it with my colleague, give my input, and invariably it is highly appreciated. And that is how the system works. And once confidence is built up, then the judgment writing also improves.
And since you have acted in that court, have you ever struggled to write a judgment yourself to such an extent that a colleague will come and make substantive comments that lead to the judgment being, or the final product thereof being different from what you initially circulated?
With my judgment?
With your judgment, yes.
Never ever.
Oh, okay.
There are only cosmetic changes ever made to my judgments.
All right, thank you very much. Thank you very much, Deputy Chief Justice.
All right. Commissioner Shabangumdao, I thought your hand was up.
Thank you, DCJ. Good evening. I'm here. Judge Mayor.
Oh,
Good evening.
Good evening, Commissioner.
Mine is simple. It's with regard to your contribution to transformation. I see here it says you provided financial support to pupils and you transferred skill to newly qualified advocates.
Can you just please speak a bit?
Can you hear me?
Yeah, I hear you now.
I'm saying it's with regard to your contribution in transformation. I see here it said you assisted pupils with finance and you also transfer skill to newly appointed or newly admitted advocates. Did that include black female advocates?
Certainly, yes.
And if it did, can you boldly say you did a good job? Where are they now?
Yes.
Are they progressive where they are?
Commissioner, you will see I deal with that at length. When I was appointed as a judge in 2007, I was nominated by the Johannesburg Bar Council. And in their letter of nomination, addressed to this commission, they deal at length with all the transformation initiatives that I was involved in at the Johannesburg Bar and in the group in which I was. And we tried to eradicate the type of briefing patterns that there were, and also the gender discrimination. My wife is an advocate at the Johannesburg Bar, And she herself, over the years, experienced the gender discrimination that there is against female practitioners. So I've always been involved in initiatives, not only for females, but also for young, starting out black practitioners. For instance, to give you an example, as an advocate, we started an initiative in our group, and I was the vice chair of that group. We called it was called the Bridge Group, and we started this initiative which we called the Bridge Brief. And that is where an attorney sends a brief to the group, which brief is meant for the junior counsel. And then the more senior counsel, the senior juniors and the senior, will then mentor that young advocate and see that a top service is given to that particular client. And that in turn resulted in direct briefing to those people. That's one of the examples. Other examples are set out in the letter of the Johannesburg Bar Council, which I've quoted actually in the questionnaire at length. And then also on the bench, apart from all the training programs in which I was involved, I also became involved in the South African chapter of the International Association of Women Judges to final year law students at UJ, UNISA and WITS from 2018 through to 2020. And that was one of all the programs in which I was involved. That is probably the program that gave me personally the most satisfaction. You as a judge, or whoever the mentor is, are allocated a mentee, and you spend about 40 hours of the year with that mentee. And prior to hearing a case, my mentee will come to me and I will discuss what the case is all about. And after the case, once I've made up my mind, she will come to me and I will hear her views, and then I will tell her what my views are and why those are my views. And the satisfaction for me is to see the tremendous talent that we do have in our country, and how much such a program assists future practitioners.
Thank you, Judge. Maybe to take you further, those whom you assisted back then, do you still remember any one of them? Can you maybe indicate where they are now? Maybe one or two?
You know, I think, yeah, I did. In the record of my previous hearing before this commission in 2019, at page 10, I make specific reference to one of them. And last year, and I read now from the record, and last year in 2018, my mentee was Zinli Matluli, and she excelled. And that mentorship program involves that you as a judge spends about 40 hours of the year with a mentee, and you discuss cases before you hear it with a mentee, and then after the case, once you have made up your mind, you discuss it with the mentee again, and so the mentee becomes exposed to exactly how a judge is functioning. And that I find extremely exciting. You also build up a more long-term relationship with your mentee. The mentee knows that she can contact me whenever, and in fact, just as a matter of coincidence, I received an email yesterday afternoon, very late, from my last year mentee, Zinli, in which she tells me that she, last Monday, obtained her LLB degree and she was on the Dean's list with 2 certificates of merit for forensic medicine and critical jurisprudence. And then I quote, "I thought I would let you know," that is what she says to me, "the good news, as the mentorship program certainly contributed to my successful year."
Thank you, Judge. Thank you, Mr.
Any further questions for the candidate colleagues? Oh, sorry, I forgot about you. Go ahead.
Thank you, Deputy Chief Justice. Good evening, Justice Mayor.
Yes, good evening, Commissioner.
Just one aspect from my side that relates to a matter that you cited as one of the judgments that displays your contribution to jurisprudence. The BLA state that your judgment in United Manganese of Kalahari reveals your ability to grapple with intractable commercial transaction.
Yes.
That is the positive feedback from the BLA. Of course, I'm more interested in trying to understand how you arrived at the interpretation of the gross sale in terms of Section 1 of the Royalty Act. I want to invite you just to sort of explain to me from your contribution, how did you arrive at the resolution of the impasse between the Commissioner of South African Revenue Service and also the United Manganese around what constitute gross sales in terms of the Royalty Act, and what has to be excluded and what has to be included?
Commissioner, over the
DCJ.
years,
Thank you.
and this really is experience, I've developed the ability to unravel very complex facts and also legal issues, and then to apply the law to those facts. And that is what assisted me in arriving at that conclusion. How I normally go about in judgment writing. Many years ago, when I was appointed as a judge, now Justice of the Constitutional Court, Matopo, said to me this, and it is so true, it worked for me. Once you've gone through such a body of complex facts and complex legal problems, sit and ask yourself, what is this case really about? And by doing that, clarity comes and eventually the penny drops.
Thank you. Just to follow up on that, the effect on the judgment, on the ability of SARS to collect in view of the constraints that our economy is going through. Didn't you consider that this, to a larger degree, will affect that capacity? Because key to what SARS, the Commissioner of SARS was saying that was that exclusion of the transport, insurance and handling expenditure must only be limited to the transport, insurance, handling expenditure invoiced to the customer as part of the purchase price. I think that was the main contention of the Commissioner of SARS. Yeah. Thank you.
Well, Commissioner, what I did there was I applied the now tried principles of interpretation to the statutory document in context, and in context of the whole Act, and in the broader context. And that is how I got to that conclusion. It is by an application of tried legal principles. But it is a very difficult Act, and it was a very complex matter.
Thank you, Justice Meyer. Thank you, Deputy Chief Justice.
Any more questions for Judge Meyer, colleagues? Colleagues on the virtual platform?
I have a question, please.
Yes, go ahead, please.
Thank you. Judge Meyer, I'll just want to confirm, reading from the feedback from one of the organizations, the Delft say that impressive that 9 of the 10 judgments, top 10 judgments are reported with a recent Supreme Court of Appeal judgment marked as reportable. Is that statistic correct?
I beg your pardon, Commissioner. Sorry, I didn't hear you.
Is it correct that 9 of your top 10 judgments have been reported and there's a 10 that's marked reportable?
That is correct.
And then that there's about 260 published judgments of SAFLI of yours.
Yes.
So my question to you is this: what would the SCA miss out on if you were not to be appointed?
They will miss out on my contribution that I've already given to the jurisprudence of this country, and which is still to come, because I do have quite a few years left. I'm 61, turning 62 in December, and I may remain an active judge until 70 years old. And in fact, had that judgment been, well, I was still writing that judgment for the Supreme Court of Appeal when I filed my application for this interview, and that is the judgment of Z versus Z, which will soon be reported. And that judgment dealt with the plight of women going through divorces, where the husbands carry on with their lucrative employment and stop paying maintenance for, say, their 18-year-old son. Invariably, there were many conflicting High Court judgments on that aspect, and whether or not a mother has locus standi to sue on behalf of a major child. Now, that leads for what, I've mentioned a few absurdities in the judgment, but one of the absurdities is nowadays so many school-going children are already major, 18 years. So, and those children don't want to sue their fathers for maintenance. And eventually, it is the mother that already came second that also tries to assist the major child through school or through tertiary college or university. And another absurdity is, say there are two children. For instance, one in grade 11 of 17 years old and one in grade 12 of 18 years old. It means that the mother can sue the father for maintenance on behalf of the one, but the other one must go and sue his father in his own name. So I love what I do. In fact, I've once, well, I still have the book. The title of the book is The Law is My Master. And that is indeed how I feel and what I will keep on contributing to this country.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner.
Follow-up, Mr.
Sorry, who's following up? Yes.
Thank you.
And please, just coin a crisp question, please, Prof.
I'll try, Deputy Chief Justice, but the judge referred to a case that has been troubling me in my mind, and I just want to pick his brain on the judgment. You know, when I read the Z versus Z judgment, and I looked at section 6, section 6.1
yes.
and 6.3 of the Divorce Act, and of course the differing opinions from the High Court.
Yeah.
And I sympathize with the view that you took. But I just want to understand, when you take away the local standing of the child to sue in their own name, because the conflict was that in the High Court, right? And then you allow the mother to sue on behalf of the child. That makes sense. I mean, the mother can come and do.
Commissioner, I'm glad you asked that question because...
No, I'm not, can I conclude the question so that you understand the context?
Certainly.
Yes. The problem I'm having is the child is over 18 and the court is taking their legal standing to sue based on convenience. It's understandable. But is it really justifiable to take the local standing, or will it be preferable at least for the Divorce Act to have deeming provisions for children? Because your main reasoning is you don't want the child to be, even though it's a dependent child, to be part of the litigation, right? Wouldn't it be more sound to have the deeming provisions which will deem the child as if it's part of the Divorce Act, as part of the part of the divorce proceedings, as opposed to taking away their local standing?
Yes. Commissioner, one thing that I made clear in that judgment is nothing can ever prevent an adult child of 18 upwards to sue in his or own name. So that child's locus standi has not been taken away. In fact, that child was not a party to the proceedings in which the court made the order, which means that that order of the court is only binding between the two spouses, and it is not binding on the child. So the child can always and will always have locus standi to sue in his or her own name.
covered? All right. Well, it does not appear that there are any more questions for you, Judge Mayor. We owe you an apology. I should have done this before we started questioning you. We kept you waiting for about 3 hours, I think. You should long be home by now. But I just want to make this clear because someone told me that there's a tweet out there that says the JSC running late as usual. The JSC was ready to start proceedings at the designated time, 12, but there was a problem with the live stream link that had to be attended by the technician, something totally out of our hands and control. So we started late and it just got progressively worse as time went on. We do apologize for keeping you waiting for the whole afternoon, and I do hope that you'll forgive us.
I appreciate that, Deputy Chief Justice. What I need to tell you also is, we call it a holding cell, and it is very comfortable in the holding cell. And there was good company, and we talked, and by doing so, we calmed each other, because it is a bit of a stressful experience, as you know.
So you did have some fun.
So I understand.
All right.
Thank you so much.
Thank you very much, Judge. You're excused.
Thank you. Thank you, Commissioners. Good evening.
This one.
You'll tell us when you're ready, Judge Ulefe. Are you comfortable? All right. Good evening, and 1,000 apologies for keeping you waiting all this time.
Thank you, ma'am.
You hold a BProc and LLB degrees from what we used to call TEFLOP back in the day.
Yes.
And you have done many things in the legal sphere. So appears from your CV, including teaching, and you've participated at various legal bodies, doing many things, and you are one of the active members of the South African chapter of the International Association of Women Judges, not so?
Yes, yes,
which
ma'am.
speaks very highly of you.
Thank you, Deputy Chief Justice.
You practiced as an attorney for 25 years.
Yes, I did, ma'am.
And thereafter took up a position on the bench.
Yes, ma'am.
Where? In which division?
I started my first acting stint in Bloemfontein Division, where I acted for 2 terms. Then from there, I went to the Gauteng Division in Pretoria.
And that's where...
I was there until I was appointed.
All right.
Yes, ma'am.
But you also have a long history with the Land Claims Court.
Yes, ma'am.
Can you tell us a bit about your experience there?
I've acted almost on a yearly basis at the Land Claims Court. At one point, I was asked to act as a judge president of the Land Claims Court because the judge president was on leave. And I've sat in a number of cases in the Land Claims Court and have written quite a number of judgments there.
How long did you act as a judge president in that court?
I acted for a term. It was not for long. Actually, it was 2 weeks less than a term. I'm not sure of the exact date, but it was almost a term.
But you had a good stint,
I had a good stint, a very good stint.
You also acted at the Labour Appeal Court as well?
Yes, ma'am. I acted at the Labour Appeal Court for 2 terms, from January last year to May actually, because from June, the 1st of June last year, then I went to the SCA to act there.
And now you are acting at the Supreme Court of Appeal?
I've been acting at the Supreme Court of Appeal until Friday, the 30th of September.
How many terms did you?
I've acted for 4 terms at the SCA.
The whole 4 terms,
yes.
All right.
Yes, ma'am.
Do you believe that your experience in the other courts, the LCC and the LAC, prepared you for the SCA?
I do indeed, Deputy Chief Justice, because then at the SCA there's no specialization. You get all types of cases. So I remember I was also on the panel where there was an appeal from the Land Claims Court, so it helped me a lot.
And how have you found your time at the SCA? Was it tough?
It's been very fulfilling, I must say. It's been very fulfilling. I was, from the moment I arrived, the now acting president, who was the deputy president then, I didn't even know him, but he phoned me before I arrived at the SCA the first term and spoke to me for almost an hour, inducting me and telling me the do's and the don'ts at the SCA, which I really, really appreciated. And most of the colleagues there were very helpful. I started acting when there was COVID and we were doing virtual hearings. But because it was my first stint, I decided to go to Bloemfontein, and I worked from Bloemfontein even if we were on virtual. And it really assisted me a lot because some of the experienced colleagues were also in Bloemfontein, even if it was virtual hearings. So I could meet with them, they could support me, they gave me a lot of support. I've been very happy.
Good. Have you been able to produce any judgments during your stint there?
Yes.
How many?
Actually, I've scribed 7 judgments at the SCA. 2 of them have been reported. But because we only finished the term on Friday, I've got 2 other judgments, but the presiders haven't decided whether they're going to be reportable or not, because that's still being circulated. But at the moment, I've scribed 7 judgments, and I've got 2 reported judgments from the SCA during my stint there.
So you have 2 reserve judgments had during this past term?
I have 2 reserve judgments, but the first one I've circulated. The second one is not circulated yet.
All right, but both were had
in yes.
All right.
Yes, ma'am.
Did you struggle with the workload? How did you cope then? Well, I know that you come from
because I come from
division.
I come from one of the busiest divisions in the country.
I was going to say that actually. I know you come from a really busy division, but people usually complain that the kind of busy in the SA is more concentrated and intense.
It's more concentrated on the law and intense, and you also have to learn to work with other colleagues, because it's not like at the High Court where I decide to write the judgment and I'm happy with it, I send it out. When you are a scribe, you have to consider other colleagues' inputs. That's where I think, but other than that, I think the workload was, I could manage it. I didn't have a problem with the workload at all.
The issue of age has been raised by this body on a number of occasions. You turn 65 in a couple of weeks.
I'm turning 65 on the 26th of October.
Is that too old? Is that something that should stop you from being appointed?
Actually, I've actually prepared a response to that. And thank you very much, Deputy Chief Justice, for asking me this question. Personally, I don't think age itself is a problematic construct. Rather, the institution that is populated by singularly elderly people and singularly young people, that's what I think the problem is. I might be on the higher end of the so-called age spectrum, but my age is accompanied by knowledge, experience. If I'm appointed, I'll continue using my wisdom, which I get from my age, to help and assist and reach people around me. You know, I also think that there is an immense social benefit to be found in transgenerational exchanges. We shouldn't just be restricted to young people and old people because we all complement each other. So I don't know if you want me to talk about, because I've seen comments that within 6 years I'll be retiring.
Yeah, I was actually going to ask how many years you have left until you retire.
In the comments, they say I've got 6 years to retire, and I wish to say that I think 6 years is a great deal of time in terms of social and judicial change. 6 years is longer than most tertiary education or degrees. 6 years is more than the number of terms given to MPs and even presidents. So 6 years of quality judgment and meticulously considered have great value and profound effect on the lives of most of South Africa. So 6 years is a great deal of time to make a change, with all due respect.
And you are in excellent health as far as I know.
Look at me.
All right. Two last aspects. The GCB laments the paucity of reported judgments that you have produced after 9 years sitting as a judge. They say you've produced only 5 reported judgments.
Yes.
And they say you may perhaps benefit from greater experience sitting in more complex matters. They don't say you should not be appointed. But just say you have not been all that productive and perhaps you need to be given more tougher work.
I beg to differ with that statement, Deputy Chief Justice Meyer. I haven't had only 5 reportable judgments. Let me start first with the Land Claims Court. I've had 3 reported judgments at the Land Claims Court. For the 2 terms I was at the Labour Appeal Court, I had 3 reportable judgments, to be exact, which I scribed. 3. I've had judgments which I didn't even include in my application. I've sat in full courts in major judgments. Some of them I was sitting with other judges, and most of those judgments we all scribed because it was a court's judgment where the presider will allocate portions of the issues of the judgment for us to write. And I chose not to include them because they're court's judgment. 2 of those judgments were actually constitutional challenges. One to the Riotous Assemblies Act. One was a challenge to, it was a Correctional Service Act challenge. One of the sections in the Correctional Service was being challenged. And both those judgments even went to the Concord where they were confirmed. I was part of those judgments. And the issue of reportable judgment is something that we are unable to control as judges. I write a judgment, I write it reportable. It's taken to the librarian. I don't know who makes a decision whether to report the judgment or not. But be as it may, I don't have only 5 reported judgments in Johannesburg. There are much more than that.
Well, you've produced 7 in a year at the SA alone.
That's the thing. In terms of writing judgments, I've written more than 300 judgments since I was a judge. But I'm just talking about reported judgment. It's not 5 judgments which were reported.
All right. Lastly, the BLA also expresses some misgivings about your candidature. They first complain that you have not said why you have not indicated which judgments you think are significant as the questionnaire, the JSC questionnaire asks you to. And they also point out that you had a number of judgments. Something happened around May 2022 that requires explanation because you had a number of significant number of outstanding judgments, which all seem to come from around that period.
Yes.
And then they say, to paraphrase you, mediocre, nothing stands out. You
Yeah.
don't stand out.
Yeah.
Yeah. What do you
Thank
have to
you
say
so
to
much.
this?
Thank you so much for giving me the opportunity to correct a number of errors in the letter submitted by the Office of the General Secretary of the BLA. Firstly, the letter incorrectly states that I have acted for only 1 term at the LCA and 1 term at the SCA. I've acted at the LAC for 2 terms, in which I produced 3 reported judgments. I've acted at the SCA for 4 terms and not 1 term. During this term, these terms at the SCA, I scribed 7 judgments. 2 of them are reportable. I was part of a panel at the SCA where there were 9 reported judgments. I was part of that panel. And I sat with colleagues in 18 unreported judgments. So what I'm saying is that for the 4 terms I was at the SCA, I sat in more than 34 matters. I also did 68 petitions during the 4 terms I was at the SCA. That's the first answer. With regard to the statement that I have significant number of outstanding judgments from my division, which came from May 2022, I would like to provide some clarification in that respect. Immediately after my 3rd acting stint at the SCA, I returned to my division in the High Court, Pretoria. During this period, from the 11th of April, I finished at the SCA on the 30th of March. On the 11th of April, I started in Pretoria. And this period was for 7 weeks because it ended at the end of May when I started again at the SCA on the 1st of June. During this 7 period in Pretoria, I picked up 13 reserved judgments in 7 weeks. Those judgments are ranging from the urgent court, post-motion, appeals, and special motions. As I'm sitting here today, all those judgments have been handed down, except for one, which is presently with the researchers, which will be handed down this week after my interview.
All right. Thank you. Colleagues, do you have questions for this candidate? Yes, Commissioner Matolo-Lebu.
Thank you, Deputy Chief Justice. I just wanted to declare that I grew up, we went to university together with Judge Molefe, and we were partners when he was still in practice, where we thought we'll change the legal profession and prove a point that as a women we can make it you know, so, but she left me behind and joined. So that's what I wanted to declare. But second, I just wanted to ask Judge Molefe that I know that she's very, very passionate about mentoring, and she's also have agreed to be a patron of Basadi ba Molao to encourage young practitioners to be able to stand up with confidence in court. If she goes to the SCA, will she still be able to do that?
Thank you, Commissioner Dlepu, for the question. Training and mentoring are my passion. As a practicing attorney, as you have already indicated, I was a lecturer at the Law Society School of Law for quite a number of years. I was also a senior examiner in the attorney's examination, the board exam. I uplifted many young women and reminded them that their efforts are just as valuable as those of their male counterparts. As a judge, because I'm passionate about training, I've conducted training to both judges and aspirant women judges under the auspices of SAJAY. I've also mentored university students under the auspices of the South African chapter, IAWJ. So it would be a real honor if I'm so pleased that I've been asked to be a patron of Basadi ba Molao, because that's my passion.
Thank you, Deputy Chief Justice.
AP Petze.
Thank you, Deputy Chief Justice. Good evening, Judge Molefe.
Good evening, Acting President.
You have already told the Commission that you acted at the SCA in total for 4 terms.
Yes, sir.
And that you produced about seven judgments.
Yes, at the moment that's 7.
Those judgments that you produced, other than maybe cosmetic suggestions from the other members of the court, would you say that you produced them single-handedly?
I wouldn't say single-handedly, because when I arrived at the SCA, I was told that the judgments are, even if you scribe, it's a judgment of the court. So I look forward to receiving any comments from my fellow judges when I'm the scribe. I wouldn't call any comment or, to be like cosmetic, per se. I really appreciate all the input from my fellow colleagues when I'm scribing. And I'm open to the fact that I might be the scribe. It's not my judgment. It's the court's judgment.
Thank you for that answer. I've been informed by senior colleagues who had assigned you judgment to write that the other members of the panel made substantive changes to your draft, as one colleague put it, in order to knock it into good shape, and what I often euphemistically referred to as a judgment undergoing major or invasive surgery. What's your response to that?
Unfortunately, Acting President, I'm unable to respond to that because I don't know which judgment is referred to. And which judgment was panel beaten. I don't know which judgment is being referred to, so unfortunately, with all due respect, I'm unable to answer that question.
That's all the judgment. You mentioned 7 judgments.
Yes.
In all of them.
Yes.
That's what the presiders in those judgments told me.
There was a judgment which I presided with you, acting president. Remember? One of the 7 judgments, you were the presider and I was the scribe.
If you could please raise your voice, I didn't hear the response.
Oh, I was saying that one of the judgments, the 7 judgments that I scribed, one of them you were the presider in that judgment.
Yes.
And I remember you referred me to one of the cases that you did. It was not panel beaten. You said to me when you scribe, just check this case, which deals with the same issue.
But in one instance, I furnished you with substantive changes or suggestions, which in fact you adopted.
Yes. Yes, sir.
Do you think that you are ready to go and work in Bloemfontein?
I am ready to go and work in Bloemfontein. Actually, even during COVID, I preferred to work. I was one of the judges who worked in Bloemfontein because I felt that I was more productive and I have a chance to sit and talk to my clerk and to the researchers as well. So I'm ready to go and work in Bloemfontein, acting president.
As you have told the commission, your last acting stint at the SCA was during the past term, 3rd term, from
Yes,
1st of June to 30th of
September. Yes, sir.
And the first day of the term was the 15th of August.
Yes, sir.
Monday, the 15th of August, 2022.
Yes, sir.
And you were not at court on that day.
Yes.
And the head of court didn't know where you were.
I was not sitting on that day, acting president. I traveled with one of my colleagues from Joburg on that day, and we arrived in Bloemfontein on Monday, but it was after tea. So we never attended tea on that day, on the 15th.
I was not aware of that, speaking for myself.
Yes, sir.
And that is not the only instance. Consistently during the term, you were not at court, and no one knew about your whereabouts. So much so, one of the colleagues came to see me and informed me that he had a petition with you. He had not heard from you, as you were supposed to have approached him in terms of our conventions, and he took the trouble to walk over to your chambers. You were not there, and your secretary informed him that you left on a Wednesday afternoon and said that you'd be back the following Tuesday. And he wanted to find out if I knew anything about that.
I don't think that statement is accurate, with all due respect. I don't think it's accurate. There were only 2 occasions when I wasn't in court. One of the occasions, me and one of my colleagues came and approached you, AP, in your chambers, because our landlord informed us that we have to vacate the place. It was on a Wednesday, because she had booked medical conference people 2 years before COVID, and they cancelled. So we approached you in your chambers, AP. I don't know if you remember, because I know it's been a very busy term. And we requested the permission, because we're not sitting on Thursday and Friday. We requested the permission that we work from home, and we were back on Sunday. We drove back together on Sunday.
No, I'm
The
aware
other
of that
occasion, yes.
particular incident.
The
Only
o-
once during the term.
That's why I'm saying it's inaccurate, and I need to explain. The second occasion which occurred, I had a family problem in Cape Town. My daughter had an operation. I left on a Friday. I was supposed to come back on a Monday. She complicated. I had a petition with one of my colleagues, which arrived on Tuesday. I phoned her. It was a her. And she said to me, don't worry, we'll discuss the petition tomorrow. Maybe the only oversight on my part was not this instant. I didn't come to you, Acting President. I must be honest. I didn't come to you to ask for permission or to phone to say, I've got an emergency. I'll only come back on Tuesday. I actually enjoy working in court. I actually enjoy working in the office in my chambers. And it's better for me to work in chambers than to work at home.
And I want to put a general proposition to you.
Yes, sir.
Do you accept that staying away from court without making prior arrangements gradually and relentlessly weakens discipline in the court?
I do accept that, sir. I do accept that.
And doing so is also an indication of lack of respect for the institution.
Yeah, that's the message that it sent, that you have no respect for, and which is not the case in my part.
No, I'm just putting a general proposition
Yes,
to you.
I agree with you, Acting
Do you
President.
accept that as a general proposition?
Yes, I do accept that. I do accept that.
And what you will not admit to is the fact that more than once, more than twice, you stayed away from court without making prior
I
arrangements.
admit that I didn't make prior arrangement with the Cape Town incident or occasion.
And you didn't see the need, even when you returned, to inform you about your challenges.
Yes, I really do apologize. It was an oversight. Actually, even the day I came to you to ask to leave to work from home, that Wednesday, I went to my presider who had just circulated a judgment to check with him to say, I won't be in court on Thursday and Friday. Are you going to have a conference? And he said to me, no, we'll have a conference on Monday. I went to my presider, who I knew had a judgment which was ready for conferencing. So I'm sorry if I send that message. I'm very respectful. I respect people. I respect authority. And I've taught that you earn the respect.
Thank you. Thank you,
Thank you, Acting President.
Thank you, President Betze. Commissioner Kies?
Thank you, DCJ. Quick question. Look, I asked Judge this question because of the statement from the BLA where they say Judge Molefe does possess a potential for the SCA, but considering the other candidates, she does not really stand out. However, when seen on the basis of the transformation imperatives, she could be a welcome addition to the SCA. That needs a significant number of women. Now, that's the statement which calls me to ask this question. Do you agree with me that for a candidate to be appointed at the High Court, at that level one would look onto the potential of the candidate, simply because, remember, he might have limited time of acting and so forth. But now, for the SCA, for the High Court such as the SCA, the candidate must demonstrate that first he or she is an accomplished judge, complete. That can be seen in terms of the jurisprudence that arise from the judgments that the candidate has written and the contribution. Do you agree with that?
I do agree with you, Commissioner Nunyetsi. I do agree with you.
Yes. Now, this statement of the BLA seems to find resonance with what the GCP is saying, because the GCP says they only have 5 judgments.
Reported.
Yes, sorry. In 9 years, there are only 5 reported judgments.
Yes.
And when I look in terms of your response to that, I hear now, but your response, you don't contradict that statement to say, no, hang on, it's not 5, for instance, I have more than that. Here are the judgments.
Yeah,
Or do you agree with that statement?
I have a list with me of judgments which I wrote in Pretoria.
No, reported.
Reported. The list is from the librarian, and from the list of reported, it's not all the judgment that I wrote, but from this list only, the Pretoria list. There's 1, 2, 3.
Yeah, my problem is that you mentioned
4, 5, 6, 7, 8, 9, 10, 11. From this list only, from the librarian, my reported judgments, it's 13.
13.
It's 13. And it's not all my judgments.
Yes, it's not all 5.
Yes.
Do those judgments include those that you said they were by the court? Remember you said some judgments are by the court.
Where I was sitting.
Look, you were sitting and you wrote as the court.
Where I was sitting as a full court.
Yes.
There's only 1 judgment which is reported here, which I was sitting as a full court.
It's part of that 13.
It's part of that 13.
But when a judgment is written by the court, how does a reader, somebody else who received the judgment is written the court, how does he pick up and say, oh, paragraph 2 of this judgment was written by Judge Molefe, paragraph 10 was written? How can you say that is your judgment? On what are they? Look, what I'm trying to say is, how would you assist me while I'm reading that judgment to say, all right, this is for Judge Molefe and this for another judge?
And I agree with you. It's very difficult because that's why the heading does not, it only says the court. And like I said, it's the presider, that is the senior judge who will be presiding, who will decide that despite the fact that we are sitting as a full court, 3 judges, I want all of us to write the judgment. It's not my decision to decide that. And you are right, as a reader, you wouldn't know who actually wrote the judgment. It's the court's judgment.
No, this is the last question, that's the end. What I just want to, I mean, I've been looking on your judgments and
Yes.
other, I have no doubt that you have made a contribution. But the point I want to make,
the SCA, in my view, should be in a position to, first, because it's a national appeal court, I mean, so to speak. That's a national appeal court. And in terms of jurisprudence that must come from that court, there must be development of the law, and there must be precedents sitting. So meaning that a judge who goes to that court should not just have a potential, it must be a complete judge. That, I think, that's the only statement I want to say.
I want to respond and say, I think I'm a complete judge, with all due respect. I think I am a complete judge.
I just think you are not. What I'm saying is a proposition that a judge who goes there should be a complete, not just somebody who has a potential, meaning that complete in the sense that written judgments, publications, there is a measurable work upon which you can say, this is a judge who has developed this.
Yes, I agree with that proposition, Commissioner Noteti.
Can I make
Thank you,
a quick
Commissioner.
follow-up?
No, yes. Follow-up.
Yes.
You may proceed, Commissioner Malema.
Thank you very much, Acting President. No, I want us to simplify this thing so that we, the laymen, understand it, Judge. Let's leave the 13. How many reported judgments are yours? Because they say you only have 5 that you authored alone and your name is there. Not the 13 that involves other people.
There's only one judgment, Commissioner Malema.
Yes.
In the 13, there was a court's judgment.
Thank
and
you.
Other than the 13 judgments, which have the list I've gotten from the librarian, I've written 3 judgments at the LAC. It was a full court, but I was the scribe. Those were my judgments. I've written judgments in the land claims court. Those were my judgments.
So how many are they, all of them?
I would say I've got 20 at the moment.
No, not the ones that you wrote, the ones that are reported.
The ones that are reported.
Yes.
The 3 LAC judgments that I'm mentioning are reported.
Including the one in Pretoria.
That's correct.
The one you're saying from 13 is 1, you mean Pretoria?
Yes, Pretoria, yes.
Then 3 plus
from the LAC,
1.
Yes. And I've got 2 reported judgments from the land claims court, which
Then-
were written by me.
Then 6.
Yes.
So we have 6 reported
12.
judgment to a name,
Yes.
plus 12 where you wrote with others, which become a court judgment.
Yes.
Okay, thank you.
And if I may add, this exclude the SCA judgments, because even if I write the judgment at the SCA, it's 5 judges, it's the judgment of the court, but I'm the scribe.
Thank you, Acting President.
Thank you, Commissioner
Thank
Malema.
you, Deputy Chief Justice.
Oh, go ahead, JP Mlambo.
Thank you very much, DCJ. Judge Molefe, I just want to deal with this court judgment because it keeps rearing its head.
Yes, sir.
Can you confirm to the Commission that in those instances where you sit in a matter that comes out as a court judgment, those are special motions as opposed to ordinary opposed motions?
Yes, JP Mlambo, I can confirm that. And
Right.
actually, most of those judgments were the judgments which were brought on urgent during COVID, which were challenging mostly the Disaster Management Act. So there were special motions which were very urgent.
Well, that leads to my next question. Your own experience as a senior judge in the division, you've sat in a number of special motions yourself. Now, I want you to tell the Commission the time it takes for a court judgment to come out compared to a special motion by a single judge.
Sure. It takes a long time. The judgment which I've just mentioned that is going to be handed down this week, it was a special motion which I was doing alone in Pretoria. And it was a complex matter which I sat for 2 days. So, and I think I should mention that when I wrote all those 13 judgments which I picked up from Pretoria as reserve judgments, I was actually working at the SCA as well. But I made sure that my judgments are not unduly delayed. I have them all handed down. It takes quite a long time to write the judgment, JP Mulambo.
What takes a long time? When you write on your own or the court judgment?
I don't know how to respond to that. It doesn't take long when it's a court judgment because the three of you contribute towards the judgment on different issues.
Yeah, because I thought you'll share with the commission that
Yes, it takes
it's
longer.
much more expedient.
It's much more expedient, especially in an urgent matter like which we got, to the three judges, each one write an issue, a legal issue in the judgment. So within less than a week, the judgment is out. It's quicker than when I'm writing a judgment, a special motion judgment on my own.
Thank you very much.
Thank you, JP Mulambo.
Commissioner Moman? Oh, you pass. Commissioner Pillay?
Thank you, Chief Justice. Good evening, Justice Molefe.
Good evening.
I just have one question. I just want to make sure I got the stats correct. Did you mention that you wrote 300 judgments in total?
For the 9 years?
Yes.
Yes, if not more.
Yeah, if not more. And then I picked up from your application that there was only one judgment that was successfully appealed?
Yes, there was one judgment, and actually that judgment was I wrote it when I was an acting judge in Pretoria. And it had to do with vicarious liability, and the SCA appealed.
And one judge.
Yes.
And then
They
one
ruled
judgment that was
against me.
unsuccessfully appealed.
Yes.
So did you only ever have 2 appeals against any of your judgments?
No, I didn't. Those are the judgments which I mentioned in my form.
Okay, I'm just trying to get a sense because I just want to look at your success rate. If you've had 300 or more judgments, how many of them were successfully appealed in total?
How many of them were successfully appealed against my judgment?
Yes.
There was only one judgment.
That's the one.
The one, yes.
And how many were unsuccessfully appealed?
There were 2 at the SCA.
All right, but so you've only had 3 appeals against your judgments.
The appeals to the SCA, you get appeals to the full courts.
Commissioner Malone?
Thank you very much, Acting CJ. I just want to understand this thing of acting. So you can be a full judge. When you go to the Supreme Court of Appeal even if you are a full judge of the High Court, it's a new environment, it's a new style of writing, it's a new way of doing things. So that thing of acting, does it give you an exposure and somehow improve your skill and teaches you how things are done differently at that level?
It does a lot, because you learn a lot from permanent judges who are there. And that's why even when you scribe a judgment, you take their inputs because you learn. You learn a lot from acting.
And when a senior judge, well-experienced judge, who has been at the SCA for quite some time, gives you, the acting judge, a substantive correction to what you have written, don't you take that as not in the negative, but in the positive, and that you are learning and you appreciate that you're getting some substantive input from a well-informed judge, whereas a deputy president or acting president? Should that be counted in the negative or positive?
I wouldn't agree with you more, Commissioner Malema. To
So
me, and I always tell myself I learn every day. I appreciate when especially senior judges make comments to my judgments.
And therefore, it will be unfair for anyone to say, I've made substantive inputs to a judgment, speaking that to be meaning the negative. Because that is the whole idea of getting you to act, to learn from senior judges, to learn how the higher court works, so that if you are appointed there full-time, you don't start to learn as a full-time judge, but you allow them, even if you are a high court judge, it's a different terrain and it has got its own dynamics and you have to learn those dynamics. And substantive inputs is but part of what you are there to learn.
I agree with you,
Thank you.
Commissioner Malema.
Thank you very much.
Commissioner Marumo Achai.
Thank you very much, Deputy Chief Justice. Good evening, Judge.
Good evening, sir. I can't see your name.
I'm also trying to understand how the Supreme Court of Appeal works. Because if I'm a litigant and I appeal to that court, and I know that at least I have 5 judges who are independent, who can be able to apply their minds in the matter, and perhaps maybe persuade each other one way or the other, I accept that proposition. I just want to understand on this substantive comments issue. Generally within a panel, all the judges I just want to understand who makes substantive comments, and are all the judges in a panel, irrespective of your level of seniority or whether you are a junior, are you able to make comments at a substantive level? Let me just make an example. Maybe as a junior judge, are you able to make substantive comments to a senior judge? And are those comments being taken? Like, what? I'm getting confused on the operations of the SCA in that regard.
Okay. Can I try to? I see it's Professor, but I can't see your name, Professor.
Marumo Achai.
Marumo, thank you. Thank you for your question. I'll tell you how it works. Let's say I'm an acting judge, like Commissioner Malema has said. I'm an acting judge, even if I'm a permanent judge in the High Court. At the SCA, I'm an acting judge. And I have to scribe a judgment. There are unwritten rules, and I've always said maybe we should be inducted, because the presider, who's the senior judge, I'm scribing. Some of the presiders would want you to send your first draft to them first so that they can make their comments. Some of the presiders will say you can circulate it to all 4 other judges. When you circulate the judgment, you expect to get comments from all the judges. And you look at the comments and you decide whether you incorporate them in your judgment. Like I've already said, it's a judgment of the court. Unless, of course, if I'm dissenting with the decision. But the presider, who's the senior judge, get to see the judgment first and has to make his comments or contributions. I hope I've answered.
No, you have. I think my general confusion is in relation to the general things that are happening in that court.
Thank you.
Thank you very much.
Have you finished, Commissioner?
Yes, I have, Deputy Chief Justice.
Okay. Commissioner Dodov?
Yeah, thank you. This is just a small point. You became a judge in 2013.
That's correct.
And you only started acting at the level of the SCA last year.
Yes, sir.
Why did it take you so long to get this opportunity?
To answer your question, Commissioner, you get invited to come and act. You don't go and ask the president or the JP of a court that you should come and act. You wait to get invited.
Okay, thank you.
And I was invited only then, last year.
It means a person who invited you, and I would imagine is the president,
It's President
could have seen
Baya.
something, a sparkle out of you, a modicum of potential to can act at that level of the judiciary.
I think that she
Now,
did.
my question would be, over and above that, you just said, I bring experience. What is it that you can bring if you are appointed that is different, that is exceptional, given your age?
Wisdom coming to age. But having said that, I don't know if I'm repeating myself, but I've acquired a vast and extensive experience of the law during my 9 years, even if I only started acting at the SCA last year as a judge and one of the busiest division. And I've also been fortunate enough to have an opportunity to act at the Land Claims Court and the Labour Appeal Court. And I've written judgments on a variety of legal aspects, as well as addressing constitutional issues and principles. So I also strive towards an accessible and sound justice system that promotes our constitutional values at all times.
Nice, okay. Thank you, DCJ.
Just a quick follow-up. I forgot this issue of the age and the retirement. The Chief Justice of the Republic of South Africa was appointed Chief Justice when he was left with how many years?
I think it was 2
years.
I'm not sure. I'm not sure.
Is it unheard of for a judge to be appointed to any other level when he's left with 5 or 6 years?
6 years, Commissioner Malema, 6 years.
Is it unheard of in the judiciary?
It's not.
Thank you.
Thank you, sir.
Okay, go ahead.
Thank you, DCJ. Judge Molefe, there's just one aspect that I want to clear with you. The convention at the SCA has always been, as when you are allocated a judgment, you write the judgment, and when you are done, you circulate it to the other members of the bench.
Thank you.
Isn't that the conventional?
Thank you, Acting President. Thank you for that. But I've sat with senior judges who specifically said, before you circulate the judgment, you must send it to me.
I know, speaking for myself, I have had a preview of a judgment before it is circulated, only when the scribe says, could you look at this judgment and see if you are satisfied with what I've produced? And invariably, I would then give the scribe my comments and suggestions.
I've noted that, Acting President, but if I may, my first reportable judgment at the SCA, I circulated it first to everyone. And I was told that I shouldn't have done that. It was supposed to have gone first to the presider. And I've met senior judges who are presiding who would say, circulate the judgment. So, and I'm prepared to obey everybody's style. If the presider wants the judgment first, I've got no problem with that. If he wants it to be circulated, I've got no problem with that.
Thank you very much for raising this, and I will discuss it with all the presiders at my earliest opportunity, beginning of next term.
Thank you, Acting
Thank you.
President. Thank you.
Just as a follow-up to what AP Petse raised with you now, Are you aware that the SCA does actually have an induction committee which he chairs and in which Justice Madobo, before he was elevated to the Concord, was very active in? And I do suspect that he would have been one of the acting judges that he worked with.
Deputy Chief Justice, actually, after that incident where I thought I made a wrong decision by circulating and I was called to order, I requested an induction, and there was an induction made. That was last year. There was an induction which was, we were called for an induction, and yeah.
Well, things might have gone lax because of the COVID outbreak, and we were all working from home.
Yes.
Sorry about that. Okay, he's covered the other thing. Okay, the last thing is that, as far as I know, in all my 17 years at the SCA, all panel members in a matter, junior, acting, senior, are fully entitled to comment, and those comments may take whatever form. They may be substantive, they may be cosmetic.
Yes.
And, well, a colleague is, of course, free to disagree with you and refuse to take them.
It's true.
If they are not persuaded. You
Yes.
agree with
I do agree
that
with
has been
you.
your experience.
I agree with you.
Thank you.
Deputy Chief Justice.
You had your hand up at some stage. Do you still want to pose questions? Go ahead, please.
Thank you, DCJ. Good evening, Judge.
Good evening, ma'am.
I'm a little concerned about your application. There are many omissions and some inaccuracies, and I just want to ask you to respond to that. We spent some time trying to sort out how many reported judgments you had, and I'm not sure why you didn't list them. Likewise, we had to spend time how many of your judgments had ever been to the SCA. You'd only chosen 2, inexplicably. You didn't say why your judgments were significant, which judgments you thought were significant. You
Yes,
didn't explain why,
I didn't.
which was part of it.
Yes.
Page 11, where you asked for reported judgments. The one is not even properly cited. It took me ages to find it because it's not properly cited. National.
Sorry, ma'am, you said
Page 11.
11.
Number 2, National Directive of Public Prosecutions ex parte. That's all that's there.
That's the citation. It was an ex parte application by the National Prosecuting Authority.
And it has no citation, no year, no number, no.
I think it was a mistake on my part.
Then 3 is an attachment, which is Annex B. Then which cases have been reported?
Sorry, I'm looking for my application. You say page 11.
Page 11, yes. Cases are under clause 16.
That's mine. It's not page 11. Yes, ma'am, I got it.
So you see there's an incomplete citation there.
Yeah, it doesn't have the... But if you look at that page 11, I've made an annexure because I had more cases to put in than the space allocated. So I made an annexure to all the cases with the
Yes.
citations at the back. I wrote C annexure.
Yes.
Yes.
And that's my next question. You say see attachment. Then the next question, 16.2, which of the cases have been reported? And you say all of the above. But it's not true that all the cases in Annexure B have been reported. Many of them have not been reported. So
all these cases until 10, the annexures list, these are reported judgments.
Well, not according to the citations here. That's why the GCB said there are only 4 or 5 reported judgments, because that's what appeared on your application. There's no letter of good standing in this application.
A letter of good standing from where?
Well, it's supposed to be part of your application to have a letter of good standing, isn't it?
A tiny...
Judges don't, excuse me. Excuse me then. I take that one back. But I'm concerned. I'm concerned that, there are a lot of, there's carelessness. There's an omission around why judges are significant, judgments are significant. I'm concerned about the quality of the application, and I wanted to give you an opportunity to respond to that.
I've noted your concern, and I can't argue with that. So I've noted it.
Was that all, Commissioner? Okay. Commissioners on the virtual platform, do you have questions for Judge Molefe?
I have no questions. Thank you, Deputy CJ.
Okay. None from you too, Commissioner Bernard?
No questions.
We don't have any more questions for you, Judge Molefe. Thank you so much for presenting yourself before this commission and allowing us to have our way with you.
Thank you so much.
You are excused.
Thank you so much to the Deputy Chief Justice and to the Commissioner for giving me this opportunity. I really appreciate it. Thank you.
Okay. And that is the end of the proceedings for the day, colleagues, until tomorrow at 9 a.m. sharp.
Commissioner Bredenbach, you must come fiscal.
I miss you too, Julius. Don't worry.